In fact, there is already an order.
Yes.
There is already an order that matter may be listed in any other DB because this bench cannot take up the matter. My Lord Justice Kete possibly cannot take up. I'm only playing that matter may be listed on Monday next for the other DB, second DB2, so that it can be taken up.
Item 27.
27, man. Monday next, my Lord, before the second DB.
Right.
Next Monday, 29. 29.
May I please ask? My Lord, with the due consent from other side, my Lord, item number 31 and 33, my Lord, be listed on Monday, my Lord.
Why Monday?
Monday, my Lord, or Friday, my Lord, this Friday.
On request made by chairman. 29.
Both, my Lord, 31 and 30.
Yes.
Okay.
Yeah, please, Lord. I beg to mention item number 24 of this speaker. What happened, Lord, I have some personal difficulty, Lord. I just would not be traced up today, Lord. Only for today, Lord. Maybe listed in the first week of February, Lord. दी हुई है हमारे 15th February. Deeply obliged.
Right. So I pray for listing of an IA Lordship. It is filed on 19th of December. What happened here, Lordship? Your Lordship has passed an interim order on 19th of December, Lordship, but thereafter the authority has passed the interim order. So that is why I filed this IA Lordship tomorrow, Lordship. But otherwise, Lordship, if inspector was he pressurized me to hand over the charge to the respondent number 4. Tomorrow, Lordship. Obliged.
May I please, Lordship, for listing this petition already been numbered 333/2024, matter relates for surface act. And one, my Lord, I am for borrower, my Lord. One essay already been subjudiced before the tribunal, recovery tribunal. That is 146. But in the meantime, the secured creditor bank issued a impugn sell notice, which is going to be held tomorrow. So, matter very urgent, my Lord. The matter may be taken up today or tomorrow.
Tomorrow.
May I,
Hello.
I beg to mention for listing, my lord, to read appeal, my lord. The 1st of February, my lord.
May it please your lordship, my lord, I beg to mention item number 23. Miss B. Devi is out of station on medical ground, my lord. She has filed letter of absence. May
D.
come.
D. Devi.
Yes, my lord.
On request made on behalf of
After 2 weeks.
2
2 weeks. Value.
May I please? Lordship, in item 43, we have filed an additional affidavit in opposition, Lordship. Affidavit may kindly be called for.
May it please your Lordship. Lordship, I am praying for a listing of a writ petition criminal day after tomorrow, Lordship.
petition criminal.
Criminal, Lordship.
Habeas corpus.
Habeas corpus. Deeply obliged.
May I please, Lord. My Lord, with the consent of all the parties, my Lord, may I prepare, my Lord, taken up the item number 17, my Lord.
Yes.
Any other date except today, my Lord.
Your good name, please.
TK Bhuya for respondent number 4, my Lord.
On request made by TK Bhuyan, that is not. Down. When do you want?
My Lord, next week, any date, my Lord.
Okay, 30.
30, my Lord. Deeply obliged.
Lordship, item number 8 and 9, Lordship. With the consent of the other side, Lordship. May I pray, Lordship, matter may be fixed on 5th of February, Lordship.
On request made by TGC.
Lordship. This is for the respondent, Lordship.
Is there M. Chanda?
No, S. Chaudhary.
S. Chaudhary. Appears for the-
Thank you. May I please, Lordship? Lordship, I beg to mention item number 43 and 44. The arguing counsel is said ill, so kindly pass over the matter for the same time, your Lord.
When do you want?
After 14th of February.
14th of February.
Yes, sir.
On request made on behalf of 43 and 44.
14. 1/4.
1-4.
14. Item 43 and 44. 43 and 44.
43 and 44. This is the TIL.
Yellow.
All Assam transfer this one.
Yes.
Are you sure?
Yes.
On request made on behalf of. When do you want?
14th of February.
14th is the holiday. We'll have it on 16th.
Okay.
May please, but I beg to mention a matter from motion. Similar matters notice has already been issued, Lord. One of the matter has come on 51 for hearing today, but if some matters were listed for motion could not be reached on the other days, Lord, let the similar matters be listed together so that it can be finally taken up.
Which matter?
Each of request matter for motion. Similar matters notice has already been issued, Lord. Therefore, on Wednesday, the 3 matters are yet to be listed. Therefore, it can be fixed with today's matter. Therefore, I beg to list it for motion on Wednesday.
Okay, with
May please, your Lordship, I beg to mention item number 19, 20, 21, 22, Lordship.
19.
20, 21, 22.
Let's start with 18.
Sorry, Lordship.
Let's start with item 18. Item 18 to 22, isn't it?
Yes, Lordship. But I'm paying on behalf of MS K Devi, Lordship. He is out of station, Lordship. And this matter may be adjourned.
For on request made on behalf of MSK Devi, learning council for the absent in Repeat Appeal number 171 of 2023, which it matters when
After 4 weeks. Okay.
May I please, your Lordship? Lordship, with the consent from the other side, I beg to mention item number 46. As my senior Mr. S.K. Methi is out of station. Lordship, matter may be taken up on 5th of February.
on request made on behalf of learning council for the absent.
Deeply obliged, Lord.
May please, your Lordship, I may mention my matter for withdraw. The item number was WPC 208-2024, which was filed on 11th January.
What do you want?
So for withdraw, Lordship.
You want it listed
Yes, sir.
when?
No, sir. It is already listed.
Today?
Not, no, sir. It was listed for 19th February. With consent of my senior and the client, they are saying that for withdrawing that matter.
So when do you want to get it listed? It's fixed on 19th of February, isn't
Yeah,
it?
yes, Lordship.
So when do you want to get it listed?
So we want to withdraw the matter. Okay.
You want to
Yeah,
withdraw, then you
list-
come on 19th of February.
No, list
It's
for,
listed on 19th, isn't it?
Yes.
Then, if you want to list it, prepone it.
no, we don't want to list. We want to withdraw the matter. Okay.
So when do you want to get it
Withdraw
listed?
tomorrow.
কেতিয়া লাগে তোমাক মেটাৰটো
Matter to
কৈ দিয়া Wednesday
withdraw list for Wednesday or tomorrow.
Lordship, I would like to mention item number 35, Lordship, of today's list.
Yes.
Lordship, may I pay this matter may be taken at any other day, Lordship, except today.
Yeah, request made by advocate for
35,
after a week.
Lordship.
Item 1 for motion.
May it please your Lordship.
My lord, in this case, respondent number 1, 2, and 4 have submitted an affidavit in opposition, my lord. I have received it, my lord. My lord, I want to file reply to that, my lord. So 2 weeks time may be time.
In fact, my lord, let him file a reply. In fact, my lord, this PL, nothing is there, my lord. Everything has been followed for allotment of the.
No, my lord, there is no NIT, my lord. They have not annexed any NIT, my lord.
Let him file.
Okay,
Let my lord.
Yes, my lord.
you didn't let me count. And how much time you require
2 weeks time, my
to
lord.
reply to the counter filed by the respondent? 1, 2, and 4. Please, sir.
Item 2.
Obliged.
In this case, my lord, we have got some instruction from the deputy commissioner and the principal secretary of the chief minister. My lord, principal of secretary of the chief minister, phone number 2, asked the deputy commissioner to submit the instruction directly to me. My lord, deputy commissioner not yet, my lord, my lord, submitted my lord instruction. That is why, my lord, lordship may kindly give some more time to take instruction.
None appears for the petition. On request made by DK Chapa, how much time
After 2 weeks.
for the 2 weeks time is allowed?
Item 3.
Look, as per last order, it was supposed to be taken for disposal today. Other side is absent.
Where's Majumdar?
It's not here today.
My senior is coming.
And the issue pertains to the, my lord, the selection to the post of postgraduate teachers in higher secondary school, my lord. What happened, the petitioner is proposing MSc in microbiology and BSc with major in zoology, my lord. And then microbiology is not taken into consideration as it is not, as the petitioner is not having the zoology, my lord. But the similar subjects are sister subjects of biological science, my lord, are taken into consideration. And in this regard, my lord, the government of Assam has also taken decisions. Last occasions, they took time that they will take the decisions, my lord. The committee, expert committee will take decisions, my lord, in this regard. Education department is to respond, my lord. Don't expect me to for time. For time.
I'm appearing for Assam University. I'm appearing for Assam. It is to the education department to respond.
Yes, that's why. Where's Majumdar? After some time.
Item 4.
Lordship, this case was otherwise ready. Your Lordship. If Learned senior
council agrees, your lordship, then matter may be fixed for final disposal, your lordship. Some other day.
Notice has not been issued.
Exactly, my lord. It is still in a motion stage.
It was.
In the motion stage.
But pleadings, sir, I have already
Uh,
filed my affidavit.
Pleadings are complete, your lordship.
No, I know where the government. I
Your
know-
lordship may issue a short notice, your lordship, then fix the matter for.
Or just protocol. It will not. Who appears for the government of Assam?
Government of Assam.
Mr. And thus the government appears for the response of one
I am for the 2, 3, 4, 5.
and Mr. T.J. Bharata. Understanding of what they have the
4 and 5, 2, 3, 4, 5.
respondents to 4.5 and 5.5.
We have also filed our reply.
Reply has also been filed by. We list it for hearing.
Lordship may
admission.
fix it for
For
your
admission.
admission hearing, your lordship.
When do you want?
There are February law.
Uh,
Lordship, on 13th of February, your lordship.
No, 13, not 13.
Then 20, your lordship, 20th February.
Develop.
Interim order shall continue on till next date. Deeply obliged.
Item 5.
May please, your lordship. Your lordship will kindly peruse the last order dated 8th of January. And in fact, a priority is also, there was a direction to show that, my lord, when that particular order was served on the present rate petitioner. And my learned friend was to, my lord, read that. Each and every.
8th of January.
8th of January. Prior to it also, my lord, 21st of January, the opportunity was given to my learned friend to produce the order, my lord, the postal receipt by which the petitioners were actually served with that order. My lord, case was like this. The petitioners, my lord, came before the tribunal for re-engagement as Group D staff. Then in the written statement, they had shown that pursuant to an earlier decision of this of the tribunal, it was already communicated to them, therefore this is barred by time. So our case was that we did not receive that communication. So my lord, my learned friend was directed to produce the proof of service on the my lord.
Yes.
My lord, we have contacted the postal department, but it was 2017 matter. But they could not provide us the service report. But we speaking order was passed on 13/1/2007
That we know. That we know. We want to know when it was served upon the petitioners.
and sent by the registered post.
So when was it served?
That is what the court wanted to know.
That's what we wanted to know.
My lord, it is very difficult for us because
We can
it
give
may
you some more.
presume,
We
it
can
may
give you
presume
some
a
more time.
registered post, my lord.
You'll be having the records. The postal department will be having the records. Why can't you try make an attempt?
My lord, the only question is that it was rejected on the ground of delay. My lord, that may be set aside and the matter may be remanded back for hearing on merits. My lord.
It may, but as of today, my lord, it is impossible for us to
Then we'll
provide
give
that
you some more time.
documents.
You to make an attempt once more time afterwards. Otherwise, we'll have to proceed with whatever is there on record.
Records is
Okay, I'll
The,
give you
uh,
another 2
the
weeks time.
receipt.
I'll give you another 2 weeks time. Make
Yeah.
an attempt. If not, then we'll dispose it off. But Mr. M.K. Chowdhury, Learned Senior Counsel, assisted by Mr.
MK Bora.
M.K. Boyer, Learned Counsel for the petitioners. Mr. A.K. Datta, Learned CGC, appearing for the respondents, is allowed another 2 weeks' time to apprise this court as to when the order dated 13/1/2017 was furnished or served upon the
This may be the last opportunity, my lord.
as last chance. Stop. List after 2 weeks.
Your lordship may kindly fix a date, my lord.
You want a date?
Any date convenient to your lordship.
7th?
My lord.
7th.
All right, great.
Item 6.
Have you paginated?
Yes, Lordship. Yes, Lordship.
Yes.
Lordship, the issue that I have raised before this honorable court by your filing PIL that the identity of the indigenous Muslim of Brahmaputra Valley and the Borak Valley. Lordship, the state government, the government of Assam, in the month of July 2021, constituted a cabinet subcommittee to identify the indigenous Assamese-speaking Muslim. The intention behind to constitute the subcommittee was to uplift their socioeconomic status by way of implementing some special schemes which may be designed for them, excluding other communities. So while deciding the indigenous Assamese-speaking Muslim of Assam, the cabinet subcommittee has identified 5 subgroups of Muslims as a indigenous Assamese-speaking Muslim who are residing in the Brahmaputra Valley. And on 8 December of last year, the Assam government has taken a cabinet decision to conduct a socio-economic survey on these identified subgroups with the intention to uplift their status. So, Lordship, I have challenged the decision of the cabinet decision as well as the recommendation of the cabinet subcommittee on 3 grounds. The first, it is a discriminatory in nature. Second, it is illegal. And third, it is an unconstitutional. Lordship will find the page number 19 that they have identified the 5 subgroups.
My lord, before my learned friend, my lord, start, my lord, I like to point out one thing, my lord. Without pagination.
No, I have a copy. I have a copy. Sorry, that paginated, Lordship.
Yes, page?
Page 19, Lordship. Lordship, may I have the permission to read this paragraph?
Yes.
Assam, also fondly called Sankar Ajanod Desh, within bracket, the land of the philosopher Saint Srimanta Sankardev and Islamic Sufi preacher Ajan Fakir, is land where people from different religion, caste, and ethnicity have lived together in harmony for centuries. Muslims form an integral part of this land, and almost of 1/3 of Assamese population being the followers of Islam. The Muslim population in the state can be divided into 2 broad categories: indigenous Assamese-speaking Muslim and the Bengali-speaking Muslim. This report specially deals with the indigenous Assamese-speaking Muslims are interchangeably in the report, and both terms denote the same. There are 5 subgroups of Assamese Muslims in the Assam: Sayed, Garia, Moria, Desi, and Julha. So report is very clear that they have identified there are 2 classes of Muslims living in the Assam. One is indigenous and other is Bengali-speaking Muslim. Lordship, intention is clear. When one person has been identified as indigenous, that is the son of soil, and person who has been left out, he has been automatically being termed as an immigrant Muslim. So the people of Borak Valley, around more than 20 lakhs, I am not sure about the figure, were living in the Borak Valley since 13th century or 12th century, they have been left behind. Now, who are these five subgroups, Lordship? That historical background little bit explained in my petition. Lordship will find in the page number 7. Page number 7. Yes, in the last paragraph, the first subgroup is Desi. They have identified. Who are the Desis? The history of Muslims of Assam, page number 7, Lordship. Last paragraph, Desi. May I read, Lordship? The history of the Muslim of Assam can be traced in the 13th century. It began after the invasion of the Kamrup city by Muhammad bin Bakhtiar Khilji, a Muslim general of Kutubuddin, and about in 1205 AD, Khilji entered into Assam through Gwalpada. During Khilji's invasion, one of the tribal chieftains of the Mech tribes converted to Islam. His name was Ali Mech. Descendant of the Ali Mech has been identified by the cabinet subcommittee as a Desi Muslim. It was around 13th century ago the person was converted, and his descendant has been identified. So what will be the identification process? I don't know. There is no clear description or mechanism is designed by the cabinet subcommittee. Lordship, the second, Morias. The settlement of Muslims in the eastern part of Assam started from 1530 AD when the Muslim army under the Turbak Khan of Turkish general of Delhi Sultanate invaded Assam. Turbak Khan was defeated and killed by Yahum army soldier. Around 1,000 soldiers were taken as a prisoner and were settled in around Kaliabad, present Nagaon district of the Assam. The descendant of this group later came to be known as Moria. Next, Sayyids. The descendant of followers of Sufi saint Sayyid Mainuddin Baghdadi, who along with his Sufi group traveled from Baghdad, Iraq and settled in Haju at 1636 AD, have been identified as Sayyid subgroup of the indigenous Muslim. Next one is Julha. Julha are originally from undivided Bihar, Orissa and West Bengal and were believed to be converted from the Adivasi. Julha Muslim community found some parts in the eastern Assam. Next one is Goria. Between 1615 to 1882, the Mughal invaded Assam for 17 times. During that time, several soldiers who were fought for Mughals had become prisoners of the war. The people settled in Assam and married local women. The cabinet subcommittee identified their dependents as a Goria Muslim.
Yes.
So, Lordship, these five, while considering the historical background of these five communities, they have in the 12th century to 16th century, they have identified those who have settled in particularly in the Brahmaputra Valley. Lordship, one point is most important. When Mughal invaded India, when Afghan invaded Assam, at that time, the conception of modern Assam was not there. There was some princely states such as Ahom Kingdom, Kuch Kingdom, Dimasa Kingdom. These are there. The conception of geographical boundary of the Assam that we are living now, or in the British area, it was not at that time when Mughal entered Assam. So, if we trace the history, when Mughal came into the Brahmaputra Valley, and some soldiers were kept as a prisoner, and their descendants have been identified as an indigenous Muslim, at the same time, the three districts, Bodak Valley is comprising three districts. It was a part of the undivided Bengal and part of the Sylhet.
Where's the subcommittee report?
Lordship subcommittee report will find in the page number 16. It is a very big report. Lordship. I have highlighted certain relevant person only.
Yes, Shama.
Well, first of all, this, my lord, PIL is not maintainable because, my lord, implement of the necessary party. The subcommittee has not been arrayed as my lord respondent. Secondly, the other groups which has been identified by the duly constituted my lord subcommittee, they are also not arrayed as party respondent. And thirdly, my lord, this is a policy decision of the government on the basis of a report, and report said, my lord, that they have taken the written statement of all the groups of Muslim community residing in the state of Assam. And on the basis of that, my lord, report has been prepared and that has been submitted before the government. That is why, my lord, my humble submission, my lord, this PIL is not at all maintainable in the present form.
Lordship, may I submit one thing, that my friend has submitted 5 subgroups have not been arrayed as a party. I am not challenging the status. I am challenging that the people of the Borak Valley also shall be included as a indigenous Muslim. And thirdly, Lordship, they have made some recommendation, and these recommendations are unconstitutional because the Assamese speaking, the word Assamese speaking is indicates the ethnicity of a particular group. And the indigenous Muslim, it is a religion identity, religious identity. And ethnicity cannot be tagged with the religion. And on the basis of religion, no special welfare policy can be implemented for the upliftment of a particular religious group. It is barred by the constitution. On the basis of religion, no reservation can be done. Nothing can be done. Lordship will find what is the recommendation, Lordship?
That we have seen.
Page 20, my lord, recommendation made by the committee was based on oral and written submission made by the various groups and individuals from across Assam, and extensive discussion amongst the committee members, and committee puts forward the following recommendation. It is not that, my lord, without any, my lord,
this
exercise, that report has been prepared.
Exercise has been done
That
in
is
a
why, my
meeting.
lord, if, my lord, they had some grievances, they should have incorporated included the, my lord, members of the subcommittee.
Lordship, this
And
submission
they did
is
not-
not at all logical. Please.
They did not, my
Because
lord,
the people,
submitted
I don't
any
know
written
who are
statement,
representing. There are,
anything before
there are
the
maybe
subcommittee.
hundreds and thousands of people belong to that community. Should I impede everyone? Is it a logical submission? And second thing is that I am not challenging their status. My grievance is that people of the Borak Valley shall be included, shall be termed as an indigenous Muslim, because it is a discriminatory leaving behind a large section of people. If people have identified someone and going to implement some special policies for upliftment their status. And
keeping the issue of maintainability open.
And look, this is most important, whether a state can implement any policy for the upliftment of a particular religious group. Constitution says no. Article 16 says no discrimination on the basis of the birth, race.
Should they themselves, my lord, said, my lord, try to say that they are not indigenous Muslim. The report was prepared to identify the indigenous people
Who
of
says
the.
that they are not? It is
How,
it
my
is
lord,
submission.
other-
Lordship, my last submission. Lordship,
Petitioner in person,
Lordship, my last submission.
keeping the issue of maintainability open, issue notice. Mr. D.K. Shamal and additional senior government advocate appears for the sole respondent. List on after 4 weeks.
After 4
weeks.
The my lord, ground for maintainability may
I've
be
said-
kept open.
Yeah,
And Lordship, that I have made on interim prayer.
no,
that-
prayer for interim shall be considered on the next suitable date.
Item 7.
Obliged, Lordship.
Please, your Lordship. Lordship, this on application preferred against the judgment and order passed by the Armed Forces Tribunal. Lordship, earlier in view of the section 30, appeal has to lie only before the Supreme Court. But after that, Union of India and Lordship, Purushottam Das case delivered in 2023, it has been enlarged now. Writ petition will be started to pour in, and this is the first one preferred by the Union of India. Now, Lordship,
With that order,
impugn order is at page 22. And Lordship may come to paragraph 6. The only reason given by only following the Dharambir case, that when a ailment is not detected at the time of enrollment, Lordship, then automatically it will be presumed that he has not developed during the course. And this has been overruled, Lordship, in 2022 order, Lordship. I have furnished a copy, Lordship, that is AOR 2022 Supreme Court 3449.
Which? Whose copy?
Lordship, can you come to paragraph 25? Paragraph 25, Lordship. May I read, Lordship?
1 minute. Paragraph 25.
What exactly is the reason for a disability or ailment may not be possible for anyone to establish? Many ailments
1
may.
minute, 1 minute.
Union of India versus ex Sepoy R.
Muthuswamy.
Munuswamy, Lordship.
Yes.
Paragraph 25, Lordship. What exactly is the reason for a disability or ailment may not be possible for anyone to establish? Many ailments may not be detectable at the time of medical checkup, particularly where symptoms occur at intervals. Reliance would not necessarily have to be placed on expert medical opinion based on an in-depth study of the cause and nature of an ailment disability, including the symptoms thereof, the conditions of service to which the soldier was exposed, and the connection between the cause aggravation of the ailment disability and the conditions and or requirement of service. The tribunal patently erred in law in proceeding on the basis of a misconceived notion that any ailment or disability of a soldier not noted at the time of recruitment but detected or diagnosed at the time of his discharge or earlier would entitle the soldier to disability pension on presumption that the disability was attributable to military service. So this is what exactly has been held by the tribunal, Lordship. So, Lordship, similar writ petition has been admitted by the Allahabad High Court. I have furnished copy, and impugned order has been stayed, Lordship. Batch of writ petitions, I have furnished copy, Lordship.
You have finished copy?
Lordship. This and I too. So, Lordship will examine, Lordship. About 20 writ petition has been entertained by the Allahabad High Court. And stay has been passed, Lordship.
Okay, heard Mr.
B. Chakraborty.
P. Chakraborty, Leonard CGC for the petitioner. Stop. Issue notice. Petitioners to text us for service of notice on the sole respondent by registered post.
Lordship.
AD within 1 week. List the matter across.
Lordship in the interim, Lordship.
Where's the
They filed the execution before the tribunal, Lordship.
Where's the impugned order?
Page 22, Lordship.
Into interim. The order dated 35.
35, 2022.
2022.
Passed in OA 41.
Dash 41 oblique 2019. Shall remain suspended till the next.
Deeply obliged. Lordship, item number 11 and 12 are similar, only case number is different.
Date.
Lordship, in item, in 11, it will be, Lordship, in order dated, it's 35/2022. That is Deepak Kumar Burman.
Item 11.
Item 9. And how for CM is 3/4/2023.
1 minute. Who is the impugned order?
Lordship. Page in Deepak Kumar Burman, Lordship, it will be page 19.
The same order. But in the interim, the order date 35/2022 passed in OA number OA-37 of 2019 shall remain suspended till the next retrievable date.
And in Hauptmuseum, it is page 25. Item number 12.
Page
Hauptmuseum, it will be page 25, Lordship. Order dated 3/4/2023. OA number 14 of 2021.
order dated in the interim, order 3/4/2023
3/4/2023.
passed in OA-14 of 2021, correct?
Lordship.
Shall remain suspended.
Deeply obliged, Lordship.
Item 10.
May I please, the Lordship? This petition has been preferred against the judgment and order passed by the Learned Central Administrative Tribunal, Lordship. The relevant portion of the judgment is page 92, my lord.
Page
92, my lord. The issue involved in the case is, Lordship, the respondents in this case, Lordship, wanted the ad hoc promotion to the post of Assistant Accounts Officer, like the the scheme of Kerala, Office of the Accountant General, Kerala, Lordship. Lordship, that Learned Cat Lordship, after hearing the case of the petitioner, directed that respondents to extend the benefit of relevant portion is page 92, Lordship, second line. Direct the respondents to extend the benefit of such ad hoc promotion not only to the applicants in the light of the order dated so. Similarly situated SOGE past officials under AZ Kerala had been promoted as with effect from 25/3/2009 within a period of 4 months from the date of receipt of the copy of the order, Lordship. In this case, Lordship, in the year 2009, Lordship, there were 929 ad hoc sectional officer and 895 officials were awaiting for promotion to the post of Assistant Accounts Officer, Lordship. So, Lordship, there were total 19 IAD offices, Lordship, that in Indian and Audit and Accounts Department, 19 offices, Lordship. In 9 offices, Lordship, did not have any waiting list of that candidate, Lordship, and in 4 offices, Lordship, there are some candidates who are waiting for promotion. And in 5 offices, Lordship, there are acquit stagnation, my lord. So, Lordship, to mitigate that, Lordship, and to give the opportunity to the candidates to promotion, Lordship, our CAG officers introduced one scheme, Lordship, that Lordship will find in page 26, Annexure 2, my lord, to regularize the ad hoc employee who are awaiting for promotion, Lordship, to the post of Assistant Accounts Officer, Lordship. Scheme is, Lordship, scheme for regularization of existing ad hoc section officer and promotion of waitlisted past officials as ad hoc section officer, Lordship. Lordship, and by following that circular, Lordship, the Office of the Accountant General Kerala, Lordship, had promoted 101 candidates, Lordship, who were waiting to the post of Assistant Accounts Officer, Lordship. The petitioner respondents in this case also wanted that we also similarly situated, we also want that similar promotion, Lordship. But issue involved in this, in respect of, Lordship, Assam, Uttar Pradesh, Bihar, and Assam, some different, Lordship. Because, Lordship, by this time, Lordship, Uttar Pradesh, Madhya Pradesh, Bihar, and Assam office, Lordship, there are another 5 office formed. Lordship, that officer, Uttarakhand, Chhattisgarh, Jharkhand, Arunachal Pradesh, and Mizoram. And in this offices, Lordship, there are acute shortage of manpower, Lordship. That is why, Lordship, our office has issued one circular, Lordship, to meet up that shortage, Lordship. From these offices, some candidates were called, Lordship, who are willing to go, Lordship. And accordingly, Lordship, one circular is issued that Lordship will find in page, Lordship, Lordship, Annexure 3, page 29. And the relevant portion is, Lordship, page 30, Roman 5 and 7, Lordship. Page 30. May I read, Lordship? Roman 5. All SOGE, that is Sectional Officer Graduate Level Examination passed, officials and those who have passed the SOG Civil Accounts as well as SOG Civil Audit will have to go on deputation to the civil offices for their eventual absorption. Those officers who are unwilling, officials who are unwilling to go to the civil audit offices on deputation now will not be eligible to get any kind of benefit under the existing scheme. And next one, Lordship, 7. Last one, Lordship. Those officials who are to be benefited from the existing scheme will have to give an undertaking to the effect that they are willing to serve in the accounts wings of the offices of AG Arunachal Pradesh and AG Mizoram for a maximum period of 4 years on deputation basis if required, Lordship. And we have given this opportunity to those candidates, Lordship, who are willing to got promotion, Lordship. And accordingly, Lordship, we have issued on notification, Lordship, you kindly give your undertaking who are willing to go. But in this case, respondents did not give any undertaking. That is why they were not considered for promotion, Lordship. By this time, Lordship, in the year 2015, some posts were falling vacant and accordingly they have got promoted, Lordship. I have given the list also. They have already got promoted, Lordship. But they want, they said that before the cap that we also similar situated person and we want the similar benefit of AG Kerala and we want the promotion, Lordship. But our office, that issue was, Lordship, our office has issued the circular, Lordship, due to shortage of manpower in the newly created office of Uttarakhand, Chhattisgarh, Jharkhand, and Arunachal Pradesh, Lordship. That is why, Lordship, we had issued that you just give one undertaking and we'll consider your promotion. And the very purpose of that undertaking was, Lordship, we want to give them promotion, ad hoc promotion, Lordship, so that they can get promoted to their next post, Lordship. And learned that below, Lordship did not consider that and directed to consider their claim like the employee of Kerala, Lordship, within a period of 4 months, Lordship. So that is why I am challenging, Lordship. So let the notice go, Lordship, and in the meantime, that order may be stayed, Lordship.
Right, Mr.
R.K. Talukdar, my lord.
R.K. Talukdar, Leonard, CGP,
Standing Counsel, my lord.
Leonard Standing Council,
IA and AD, Indian Audit and Accounts Department.
IA and AD. For the appellants, for the petitioners. Issue notice. The petitioners to take steps for servants of notice on all the respondents within bracket respondent 1 to 10 by registered post ID within 1 week from today. So, list after 4 weeks. Where's the order?
Lordship, Annexure 10, page 85, Lordship.
In the interim. The order dated 16/8/2023. Oh, no.
Order dated is next page 86, Lordship.
38.
38/2023.
Passed in OA number 040/00359/2017. Charlemagne suspended till the next.
Right.
Item 13.
Please, Your Lordships. Your Lordships, this is a writ petition filed assailing the constitutional validity of the levy of ad valorem court fees on the grant of probates in the state of Assam under Article 11, Entry 1 of the Court Fees Act. Your Lordships may hear the substantive arguments later, but today my prayer is fairly limited. Your Lordship, before this petition, an identical writ petition already has been filed before this Honorable Court, WPC 2919 of 2018. If Your Lordships may just have the order in that particular writ petition, it is at page number 73 of the file. This is an order dated 13/9/2023 of this Honorable Court, wherein the government had submitted that the matter regarding revision of ad valorem court fees as well as the amendment in other provisions of the Court Fees Act is under active consideration of the concerned departmental officials, and a period of so-and-so is being sought for reaching a final conclusion. In the next page, the Lordship will have the next order in these proceedings, in the prior proceedings, dated 9 November 2023, wherein some more time was sought by the state government, but clearly no conclusion has been reached by the state government. So, Your Lordships, this does not, at least in my view, appear to be an adversarial litigation. The government at some level agrees that the Court Fees Act, which was enacted insofar as the state of Assam is concerned, is a fairly old law, is a law that dates back to 1950s and requires changes. Therefore, Your Lordships may be kindly pleased to tag this petition, which I have filed, with the previous writ petition and issue notice in my petition, Your Lordships. I'm also happy to apprise Your Lordships on the substantive arguments today itself, if Your Lordships may so desire. There are primarily three grounds of challenge to the validity of the certain provision. Firstly, the limit is an ever increasing limit, and there's essentially no cap on the amount of court fee somebody has to pay for the grant of probate. And the manner in which the court fees is decided for probate in Assam almost amounts to taxation. The third ground is an Article 14 ground, wherein it is seen that there's a blatant discrimination between the court fees charged for probates and court fees charged for other suits without there being any intelligible differential. So these would be the broad grounds of challenge which we would be urging at the final stage. But for today's submission, Your Lordships may kindly be pleased to issue notice, direct the government to actually come to a conclusion as they have stated so in the earlier orders, and tag this matter with the earlier matter. I believe that earlier matter is listed on the 7th of February or 6th of February before Your Lordships. We've served the copy to the other side as well.
No, are you sure about what date the other writ petition is listed?
Your Lordships, WPC 2919 of 2018, identical writ petition.
When is it listed?
7th of February, Your Lordships.
Take with that matter only, Lordship, that will
Not
come
Mr.
along with.
Rangan Chaudhary, R. Chaudhary.
R. Chowdhury, learned counsel for the petition.
Then both the matters can be heard together because all the issues will be similar.
MS Boral, learned government advocate.
Government.
Interceptions on behalf of,
1 and 2, Lordship.
on behalf of all the respondents. Stop. List this matter along with WBC number 2919 of 2018 on 7th.
Lordship, let it be take with that.
Your Lordship,
That I cannot remember, Lordship.
to be honest, I'm also not particularly sure it's either the 6th or 7th. Your Lordships may just say that the matter be tagged, and accordingly the registry may take a call on the listing.
Deeply.
Obliged, Lordships.
On a date to be fixed by the registry, huh?
Timing item 3.
Item number 3,
Hmm.
the department has taken up the matter with experts, and another meeting is again fixed on the 30th of January, madam, to bring about the equivalence part in
Now,
the
where is the
different
petitioner's
subjects.
counsel? Where's Purkayasta?
They are seeking an equivalence of the higher education standard. It is not upon only the secondary education department who can take a call. We took a advice of the higher education department, who then referred the matter to the different university professor experts to find out whether there is an equivalence.
Have you gone through the last order?
My lord, yes, my lord, but then the department, my lord, is not holding back anything. My lord, we are trying to find out if there is an equivalence. Perhaps the petitioner will have a case. If the opinion of the experts come otherwise, then we'll have to bring up our affidavit on that line. We will not have other options. It is not an administrative decision we can take, my lord. That is the only difficulty. Had it been an administrative decision, I could have.
Okay, you wait for
Right.
some time, let petitioner's counsel come.
Item 14 for admission.
My lord, your lordship heard the matter on two earlier occasions.
Okay, good, Lordship. Lordship, I'm appearing on behalf of Soma UGC. Lordship, we have not received complete instruction in this matter, Lordship. Earlier order we have to file. According to the earlier order, Lordship,
What
we have
order
to
was
file.
passed? 1 minute. No, no. UGC has to file an affidavit.
Lordship,
My lord, I will explain that matter, whether the lordship has passed that order, but whether it is required to file an affidavit. The lordship, I'll take your lordship to page 88 of the judgment. My lord, it's a case where the learned single judge has passed an order that MPhil is a valid degree. Now, if MPhil is a valid degree, I am entitled to get 5 marks. And for teaching experience, I'll get 5 marks. Now, the UGC never filed any affidavit before the learned single judge. They did not challenge. In that view of the matter, it has reached its finality. And it is not required to file an affidavit, even if it is filed. Your lordship will rather, I will say, cannot give any credence to that. My lord, I will take your lordship to 2 judgments to satisfy just now, my lord. My lord, they will say something, although it's not on record, and then they will say they will file affidavit. My lord, so many dates has gone, they did not file.
Who appears for UGC?
Lordship, I'm appearing on behalf of K. Soma, Lordship. He is listed on court number 13, Lordship.
Hmm.
Can it be for time being, Lordship?
Then she's here after some time?
Yes.
Item 15.
My brother will start the argument.
No, Mr. Paunam, like I said in the earlier occasion, I may not be able to take up this case. Some development has taken place, very unfortunate.
Lordship, I have already addressed the
Yes.
time at my lord.
Last time when you came,
Yes.
that time also I told you.
Yeah,
I may
that's
not,
right.
able- I will, because now,
The thing is, lordship, this matter being hard and having hard and again, getting released from bans.
Problem.
there is. If you are, if you you have any urgency involved,
Yes.
Then,
There's urgency system.
we can,
Urgency, they said that there's no urgency from our side, there's urgency, but because Lordship, I'm moving this with the bill
Oh.
for the last, since I think, since August, now this is January, my lord. For some other reason, Lordship, this matter, any kind of order can be passed in this matter. This was hard by bench earlier.
I
Then,
know, it was reserved. and
Right.
Then,
For us, I don't know, what last week that I don't understand better. I already cannot argument. Like, we will like contribute to the area you are coming from.
no, no,
But as you also have difficulties. What's the option?
something has happened very unfortunate. I can't take up the matter. But I can, we can, if you're expressing urgency, we can fix a date.
We was thinking that
today,
in
can be
Manipur,
possible, my lord.
today and tomorrow.
Today will not be possible.
Tomorrow,
Morning. And we are coming tomorrow. Will not be possible for us.
On some other day.
Give a
Today-
convenient date for both the parties, you discuss.
I can be happy in the first week of February.
today, tomorrow, it is closed in Manipur, my lord.
Okay.
So tomorrow, if we can have tomorrow, Lordship, I can complete within the 45 minutes or so, Lordship, I can continue. And then
No.
we can leave by evening flight.
No, it will not be possible. I have tried many times for leaving in the evening. I have to cancel my flight again. My lord, can be fixed in the first week. No problem. Because 24, my
Yes,
lord,
Paunam.
in the first week, my lord, we no problem. Because 24, many cases has picked for me, my lord. In this, I have to go tomorrow morning.
24, 25th, there are about 35 meters, my meter.
That's why we are requesting.
But anyway, Lordship, I can adjust here. That is the problem because this is long-standing matter.
List this matter before any other bench. without one of us. You put my.
8:30.
Hmm.
8:30.
Matter release from parted.
Let us have it on.
No.
Ito nung by the 8 height.
As the party
Mga diya,
expressed,
mga diya, DBM
Mga
le.
Monday na again.
DBM le
list
ba iki?
the matter
On the
again out.
50.
When do you want?
Malo, can you fix in on Thursday or Friday, man?
We can have it to the lordship on the second or no, second. Second is a Friday.
Yeah. Second or third, man.
So right.
I have no issue.
Second February. Tarun Kumar, when are you leaving?
Tomorrow we are.
Tomorrow morning, 9:30, we are taking a flight.
Me and Devan, we are leaving tomorrow morning.
We was thinking that, my lord, it was almost part hard. So we can complete it by 1 hour, my lord.
Can you come to my chamber once? At
You
one,
can come, man.
at one,
Alone, man. He alone.
alone.
Yes. Okay. Right. Then, my lord, this Farhad has to be released over.
I will.
Always.
Item 3.
May I please? And this petition will be disposed of with the direction to the state respondents to my lord to place the issue before the expert committee to take a.
No, they've placed it before the expert committee.
They have not placed yet.
They are going to have a meeting on Wednesday,
30th of January, my lord, that is my
30th of
intention.
January. So let us wait.
What actually, my lord, why the matter is before this honorable court
That
is
we know.
because they have, my lord, they have also challenged a rule where we have laid down the qualifications. They want an amendment of the rules itself. Equivalence of the degree they hold would not perhaps amount to amending the rules in that sense, my lord. We need not amend the rules, the recruitment rules for that matter. Therefore, my lord, because this is a matter which requires that expert opinions and everything. Keeping it on short dates would not, my lord, help because we need to have the opinions of the experts flowing in before we can take a decision, and we do not control those experts. They may send a letter today or they may ask for a meeting on another day. So if lordship has it sometime in the mid of February, perhaps we can have some. Otherwise, if it's not.
As your lordship.
Be progression and the counsel for the petitioner. Stop. Mr. R. Majumdar, and Standing Council, School Education Department submits that the department has placed the matter, has placed the matter before the expert, before the experts, and the meeting would be held on the 30th of January 2024. Stop. Accordingly, list this matter. When do you want?
Well, sometime after the second week of February, my lord, we can then come to a conclusion.
15th of February.
15th February.
Obliged.
Item 16 for admission.
May please, the lord.
My lord, in this case, my lord, we have already filed 16 affidavits. 5 more are needed to be filed, my lord. It has been reduced and it is gone for vetting. Some more time is needed, my lord.
No, the direction was issued in the last year.
Yes, yes.
2023.
Yes.
So the requirement is that they file their affidavit as early as possible. Otherwise,
How long are you going to take?
At least 4 weeks, man.
Work for it. When was the last order passed? 11th of December, isn't it?
yes, madam. 11, 12, madam.
How many districts are left?
16 has been filed already and 5 are left. 5 are, my lord, it's almost ready to be filed, my lord. And 14 will be remaining.
This is too much time, my lord. This is too much
It is
time.
Too much. I can give you 2 weeks.
Last 1
3
year
weeks,
only.
my lord, 3 weeks. My lord, 1 week it will be closed only. Next, this week,
Only 24, 25, 26 is closed, 27 is again off. My
Milord,
lord.
may I
So at least
suggest
3
one
weeks,
thing?
my lord.
Let them, Lordship will permit them 4 weeks, but they'll come up with all the districts. See, in 1 year, they have filed affidavit for 14 districts, Milord. 32 districts are there.
But Mr. H.K. Das, the Standing Council, Guwahati High Court. Stop. Mr. N. Das, the Governor Advocate, is allowed another 4 weeks' time to file affidavit in respect of the other remaining districts.
Yes.
Stop. Release the matter again on February 22nd. 26th February.
Lordship will record no further time. That will help him, Milord.
It is made clear that no further time shall be given to the respondents.
Fine, ma'am. I'll leave.
Item 25.
The medical admission rules have been put to challenge hearing regarding my lord, admission under the EWS quota. Otherwise, my lord, counseling last year it is over, but put to challenge. I don't know whether Mangut is appearing for the other side. Let it be after 4 weeks.
None appears for the petitioner. Mr. B. Gogal and the Standing Council held appears for the Health Department. Please, the matter again after 3 weeks. Please.
Vote.
3
Otherwise,
weeks.
Public.
26.
May I please, your lordship? My lord, my senior is late. Kindly pass the order meter for time being.
At least I'm praying for issuance of notice only, my lord. I'm praying for issuance of notice only, my lord. Sir, I have challenged the order, my lord, of the Honorable Single Judge, my lord, at page 57, my lord. Only small.
Kindly time.
If it's just a notice, then we'll issue notice. What's the point of waiting?
Yes, my lord.
This is with April 1 of 2020. But Mr.
Yes, Hazarika, my lord.
General Counsel for the appellant.
Lord, may I repeat one thing? This order that has been challenged, my lord, it is a consent order. It has
No, my
been
lord.
passed by the consent of both the parties. My lord, may come to page number 57. Second paragraph. Mr. A.I. Uddin has also agreed to the said order, but has sought refund of the nomination fee earlier paid to his client. Paid by his client. My lord,
Only-
on that basis, this order has been passed.
My lord, I'm also admitting that, my lord, only regarding the last paragraph, my lord, upon such notification, it will be open for the petitioner to submit their nominations, my lord. We have already submitted our nomination in the year 2018, my lord. Therefore, by this rate appeal, my lord, I am praying for this modification that our earlier nomination should be considered, my lord. I'm not asking for the set aside of this order, my lord.
On that particular
No,
point
in my-
itself, they have consented, my lord. That,
Therefore, in my prayer,
It is
my
a-
lord, in the
It
appeal,
is a consenting order, isn't
my
it?
lord.
therefore, my lord, I am not.
If you agree
asking
by
for
that, if you agree by that last line,
Last line only,
why
my
did
lord.
you file a review?
My lord, it is a consent order, lordship.
No, that's why.
My lord.
It's the last paragraph that you agree. for.
Yes, my lord, only
You can file a
regarding
review of that.
nomination part, my lord.
You can file a review. That would be better for you. Otherwise, this court, when it is a consenting order, then we are not going to interfere with the order.
My lord, I pray to withdraw this repeal and with a liberty to file the review.
Mr.
Yes, Hazarika, my lord.
Yes, Hazarika Learned Counsel for the appellant prays for withdrawal of this writ appeal with liberty to file a review petition.
I'm appearing for
Mr.
Corporation Department.
Ms.
MD Bora for Corporation Department.
Vora, Learned Standing Counsel appears for the Corporation Department.
LMS, so let a government advocate appears for respond number 4. You government advocate. Stop. With appeal is dismissed on withdrawal with liberty aspect.
Deeply obliged.
I'm deeply obliged.
28,
My lord, may I kindly fix the matter of next week, my lord. If possible, Friday, my lord. We have some difficulty today.
On request made by Mr.
Yes, that's my lord.
S. Das Leonard.
Standing council higher division.
Standing council higher division. Mr. Metron, when do you want?
My lord, 2nd of February, my lord.
2nd February.
Much obliged.
29,
Your Lordship, the petitioner's case was that while he was still in service, a criminal proceeding was started against him. In the meanwhile, he retired. And thereafter, Your Lordship, the trial court convicted him. From the date of his retirement till the date of conviction by the trial court, a provisional pension was granted by the department. And from the date of conviction, authority has withheld it. His case is that, Your Lordship, he preferred an appeal which is still pending before this honorable court against that conviction order passed by the trial court. Since the appeal is admitted, so he is entitled to provisional pension. That was his case, Your Lordship. And the learned single judge, Your Lordship, allowed his writ petition, Your Lordship. That's it. Our case is that this is settled law.
Where's the order?
Your Lordship, page number 77, Your.
Yes.
Your Lordship, the operative part at page number 89, Your Lordship. Page number 89. Now coming the argument and judgments relied on by Mr. Kumar, learned additional Assam, this court is of the view that the context in which the judgments passed by the Honorable Apex Court that have been relied upon by Mr. Kumar is not applicable in the given facts of the case in as much as present case relates to a payment of pension and the legislature in its wisdom specifically used the word emphasis on conclusion and finality of judicial proceeding. Therefore, judgment which relates to the exercise of power under Article 311 and relating to execution of decree is not applicable in the present case. Inasmuch as dismissal of government servant cannot be equal with a person who has retired and who is entitled for pension. In the considered opinion of this court, pension being a very valuable right, the legislature in its wisdom has incorporated the provision of Rule 22 of Rules 1969 so that the pensioner survives till the allegation made against him attains finality. That is the findings of the Honorable Court, Your Lordship, the learned
session that learn at the single court that the lordship. So your lordship, this is settled law that once a person is convicted by the trial court, he will remain or he will treated as a convict until and unless the higher court reverse this decision by way of filing by way of a appeal or revision, your lordship. In his case, your lordship, it is not interfered, it is still pending. There is no suspension order of so far as conviction order is concerned. Only he was on bail. The sentence was suspended, not the conviction. So this is settled law. The constitution bench of this of the Supreme Court is clear in this matter. That once it is convicted, then he will be treated as convicted until and unless he is acquitted by the higher appellate court. Your lordship, kindly see the under Rule 21 of the Assam Pension Rules, your lordship, 1969. Rule 21, your lordship, this book, if it is the same book, your lordship, page number 10. May I read you?
Yes.
The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government if in a departmental or judicial proceeding, here in the judicial proceeding, the pensioner is found guilty of grave misconduct. Your lordship, the criminal proceeding was initiated under Prevention of Corruption Act. So accordingly, he was convicted, giving 4 years punishment and 20 lakhs of fine, your lordship. So that is grave misconduct, your lordship.
Yes.
Your lordship, the learned single judge also relied upon the Rule 22, your lordship. Page number 13, your lordship.
Yes.
Where any departmental or judicial proceeding is instituted under Rule 21, or where a departmental proceeding is continued under Clause A of the proviso thereto against an officer who has retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final orders are passed. A provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of retirement. Your lordship, the learned single just observed that since the appeal is the continuation of the criminal proceeding, he is entitled to provisional pension. Your Lordship, in the catena of judgments and the judgments passed by various division bench of various high courts of the country, it holds that even in the parameteria provisions, it holds that if the court of first instance convicted the employee, then until and unless it is reversed by the higher appellate court, he will be treated as is a convict and he will not entitled to any provisional pension. And
Where is that?
Yes. This is the judgment passed by the Madhya Pradesh High Court. Is a division bench judgment, Your Lordship. Division bench judgment. A similar fact situation, Your Lordship. Your Lordship may kindly second page of the judgment, Your Lordship, the operative part. Learned single judge, Your Lordship. Second. The learned single judge considered the facts and found that after conviction of the appellant was not entitled for provisional pension, and the aforesaid provisional pension was allowed during the pendency of criminal proceedings against the appellant, and after conviction of the appellant was not entitled to provisional pension. The learned single judge also considered that merely an appeal was filed and his sentence was suspended will not be ground to treat that appellant was not convicted, as the effect of suspension of sentence would be that the appellant would not suffer jail sentence. However, his sentence shall be subject to decision in the appeal. Reliance was placed by the learned single judge to the judgments of Apex Court in Ramanarang versus Ramesh Narang and Sasan. To appreciate the contention of the appellant, it would be appropriate that if the provisions as contained in relevant Rule 64(1)(b) of the pension rules, which is parameter to our provisions, the provisional 64, it is quoted here, the provisional pension where departmental or judicial proceeding may be pending. Your Lordship, the next page, B. The provisional pension shall be drawn on establishment of pay bill and paid to retired government servant by the head of office during the period commencing from the date of retirement to the date on which, upon conclusion of departmental or judicial proceeding, final orders are passed by the competent authority. That part is parameter, I know. In the similar, this is in the similar facts and circumstances, Your Lordship, the division bench of the Madhya Pradesh High Court upheld the single bench judgment. The aforesaid provision specifically provides that an employee after attaining the age of superannuation shall be entitled for provisional pension to be drawn by the head of the office during the period commencing from the date of retirement to the date on which, upon conclusion of departmental or judicial proceedings, final orders are passed by the competent authority. In this case, the judgment was passed by the special judge Rewa, by which the appellant was convicted. So far as the phraseology used that final order passed by the competent authority, it does not relate to the final authority in respect of payment of pension, but it relates in respect of the departmental or judicial proceeding, which are referred in clause B of sub-rule 1 of Rule 64. The criminal proceedings remain pending after retirement till the passing of the sentence, and after conviction and sentence, the appellant was not entitled for provisional pension, and even in this regard, it was not necessary to pass another order by the competent department authority. So in the division bench of the Madhya Pradesh High Court, in the similar fact situation, in a parameter provision, on a foundation of a parameter provision, Your Lordship, it held that the provisional pension is he is not entitled to provisional pension until and unless order of conviction is reversed by higher appellate court. That is one of the judgment. Another judgment. It's a division bench of it, your lordship, Delhi High Court, your lordship. It is similar situation.
Yes.
Your lordship, the paragraph 18, your lordship. Paragraph 18 at page number 10, your lordship. Page number 10, paragraph 18. Your This thrust of the petitioner's submission is that since his criminal appeal is pending before the High Court against his conviction and sentence, and as the sentence has been suspended, similar to our case, your lordship, present case, by the appellate court, his conviction has not attained finality since appeal is a continuation of original proceeding. He also relies upon Rule 69(1)(b). In our case, your lordship, Rule 22, which provides that the provisional pension shall be authorized during the period commencing from the date of retirement up to and including the date on which, after the conclusion of departmental or judicial proceeding, final orders are passed by the competent authority. The submission is that judicial proceedings cannot be said to have attained conclusion in view of the pendency of the criminal appeal. That is the submission of the petitioner. Your lordship, that is the case of the petitioner. Your lordship, it was answered by the division bench of Delhi High Court. The immediate on paragraph 19, the aforesaid submission of the petitioner has not merit. Your lordship may kindly turn to page number 14, your lordship. 25. Page 14, paragraph 25. Lordship, find it?
Yes.
Yes. The position is no different in the present case. The ratio of the aforesaid judgment is clearly applicable in the facts of the present case. The petitioner is liable to be treated as corrupt until he is exonerated by a superior court on merits and not on mere technical grounds, such as lack of or irregular sanction to prosecute. Merely pendency of his appeal does not even temporarily absolve him from the findings of guilt. Though the petitioner stands convicted and sentenced by the trial court, he is nevertheless seeking to assert his claim for provisional pension, which, in the fact and circumstances, is equivalent to his regular pension during pendency of his criminal appeal. Thus, the petitioner is asserting his claim if he is a government servant who has retired without any blemish, even though he stands convicted and sentenced by the trial court for conduct which also tantamounts to grave misconduct. He is seeking to draw on a monthly basis provisional pension equivalent to his regular and full pension, which would not be recoverable even his criminal appeal were to be dismissed. A similar situation. As per the rules, we cannot recover. Suppose then after a few months his appeal is dismissed. Even then also we cannot recover whichever already been paid. Next paragraph. In our view, the state is not obliged to financially support a government servant who has been found guilty in a case of corruption by criminal court, either provisionally during pendency of this criminal appeal or otherwise. Such a government servant who stands convicted in a corruption case ought to be considered as a parasite and a burden not only on the government but on the society at large. There is no reason why public money should be doled out to him only to await the decision of the appellate court, which is pending at his behest against his conviction and sentence. So, Your Lordship, may kindly turn to page number 18, Your Lordship, paragraph 31, Your Lordship. Here also this,
Yes.
having given our anxious consideration to the matter, we cannot persuade ourselves to agree with the review taken by the Karnataka High Court in such and such case. Under clause B of Rule 69(1), the relevant expression used is from the date of retirement up to and including the date on which, after the conclusion of departmental or judicial proceedings, final orders are passed by the competent authority. Pertinently, while making the said rule by resort to proviso to Article 309 of the Constitution of India, the President uses the expression final only once. That is important, Your Lordship. President uses the expression final only once, that is in relation to orders which are passed by the competent authority. However, so such word or expression is used before the word. However, no such word or expression is used before the word conclusion of departmental or judicial proceeding. If the intendment of the president while framing the said rule was to release provisional pension to the government servant up to the date of final conclusion of departmental or judicial proceedings, the president would have used the said expression final before the words conclusion of departmental or judicial proceeding. The same here in our provisions also, Your Honor. Just as he used the expression final in respect of the orders to be passed by the competent authority. Thus, the plain grammatical and literal interpretation of clause B of Rule 69 does not support the interpretation that the conclusion of departmental or judicial proceedings means the final conclusion of departmental or judicial proceedings. That is the finding.
Yes.
Your Lordship,
Here's a point.
Your Lordship, this is the interpretation adopted by the other high courts, Your Lordship. Even the Supreme Court in Katana of judgments, Your Lordship.
But Mr.
K. Kumar, Your Lordship.
Leonard, additionally,
Yes, Your Lordship.
Assam for the appellants. Admit
There is an interim prayer, Your Lordship.
appellant to take steps for service of notice on the sole respondent
Your Lordship, yes, sole respondent.
by registered post AD within 1 week from today. Stop. List after 4 weeks. In the interim, the order dated. Where's the order?
Page number 78, Your Lordship, 10/10/2023. Your Lordship. It starts from 77.
The adjustment and order dated 10/10/2023. Passed in WBC number 5034 of 2020 shall remain suspended till the next reasonable dates.
Oblige, Your Lordship.
Item 30.
The matter pertains to settlement of the market order under the Barpeta Zilla Parishad. The tender was issued on 3/5/2023. The two clauses are there. More particularly, clause number 10 and 20. But clause 10 says
if the highest bidder is deficient with regard to the certain document, except the court fee and the earnest money, in that case, he'll be given 3 days time to submit those documents. And clause 20, it says once the notice of acceptance has been given, he should deposit the case money and the security deposit within a period of 7 days. Now here in this case, my lord, out 6 tenders were there, my lord. Out of them, my lord, the first bidder, the highest bidder, my lord, his tender was accepted by the the standing committee, and but he thereafter withdrawn. So thereafter, the second, the highest bidder, who is the writ petitioner, he was given the a notice of acceptance to deposit the certain documents within a period of 3 days, along with the kist money and the security deposit. Now, he having failed within the period of these 3 days or the 7 days, on 14, the standing committee taken a resolution to issue the notice of acceptance to the present petitioner, who is the present appellant, who is the third highest bidder. Accordingly, I have deposited the necessary amount and also the documents. And my lord, the settlement order was passed on 19/7/23, my lord, settling that market in my favor. Now, my lord, after the standing committee taken a decision on 14/7/23 to issue the notice of acceptance to the third bidder, that is the present appellant, on 15th, my lord, the writ petitioner, who was the second highest bidder, he submitted an application to accept his amount. But by that time, the 3 days or the 7 days all were over. So, and it was not before the standing committee on 14/7, because it was on 15/7. Nonetheless, my lord, he filed a writ petition before this court. My lord, his basic contention is that the notice of acceptance dated 6/7/2023 had been received by him only on 10/7/23. And therefore, he having submitted his application for on 15, it is within the 7 days time. So therefore, the rejection of his tender and the settlement of the market in favor of the present appellant is illegal. But during the course of the hearing of the writ petition and the affidavit, what has come up from the government as well, it clearly appears that on 6/7/2023 itself, he was served with the notice. But nonetheless, the honorable single judge, having primarily concerned with the amount of the bid, as well as non-consideration of his application dated 15/7/2023, has set aside the order of the settlement, and the direction have been issued to settle the market in his favor for the remaining period. Now, this apparently, finding of the honorable single judge with regard to the non-consideration of the application dated 15/7 is perverse, because meeting was held on 14/7, notice of acceptance was issued to me on 14/7, and the 7 days time has expired on 13, and he has submitted his representation only on 15. So on that ground alone, the settlement order ought not to have been interfered with. The chief will kindly find the judgment, is at page 40. Relevant, the Lordship may come to page 43. Or Lordship may come to page 44, paragraph 13 onwards. From the records made available, it appears that in the process of settlement of the aforesaid market in question, which was done through an NIT dated 3/5/23, amongst other bid were submitted by the petitioner and the respondent number 5. There is no manner of doubt that the bid of the respondent number 5 was not complete in many respects, as many of the columns in the comparative statement had indicated that the relevant document was not submitted. Juxtaposed, the bid of the petitioner was found to be valid in all respects. Apart from the aforesaid aspect, it is also required to be noted that while the price bid of the petitioner was 9,21,102 only, that of the respondent number 5 was rupees 8,11,000 and all. Therefore, there is a substantial difference in the price bid of the rival parties. The version of the petitioner is that he has received notice of the acceptance dated 6/7/23 only on 10/7/23, The said version, however, is not liable to be accepted in as much as said notice was accepted by his wife on 6/7/23 itself. However, the mere fact of acceptance may not be end of the matter. It is the specific case of the petitioner that he was unwell, and on recovery from his illness, he had submitted a representation on 15/7/23 offering the kiss money. A perusal of the said representation would show that he has cited the reason of the delay. The court has already noted above as per clause 20, an incumbent gets a period of a week for deposit of kiss money, though it may be a fact that such deposit was not offered within a prescribed period of 1 week. The fact and circumstances of the case would give a discretion to the authorities to take an action in the judicial manner. The copy of the resolution adopted on 14/7/23 denotes that no reason were assigned by the petitioner for delay, which not appear to be correct. My lord, the resolution was adopted on 14/7/23. The application was submitted on 15. Obviously, my lord, the standing committee had no document on 14/7. So therefore, they said, my lord, that there is no explanation of delay. It was only submitted on 15. This court is also noticed that the BW respondent number 5 was lacking in many respects and therefore could not have been held to be valid bid. Further, clause 10, which gives a leverage of 3 days for submission of the certain document, is only for the highest tender and not for anybody else. Though there is a part of clause 10 regarding the next highest tender, such next highest tender has to be valid next highest tender, and in this case, the BW document, respondent number 5, cannot be held to be valid next highest tender in as much as many documents were not submitted, as would be evident from the comparative statement. Now, Lordship will kindly see, my lord, the clause 10 at page, the Lordship will come to 21. Clause 10. For all Bazar Ghat Manmohal found, the tender of the highest tender will be accepted for consideration. If any highest bidder tenderer had not submitted the requisite document except court fee and earnest money, but except court fee and earnest money, if any deficiency is there along with the tender, then the said tender will be provided maximum 3 days time to submit the requisite documents. Now, certain documents, I did not submit along with the tender, but this so far as earnest money and this the court fee is concerned, that was deposited. And after the first highest bidder withdrawn, the second highest bidder he was offered, he did not accept within a period of 7 days. After completion of the 7 days, standing committee set for the meeting and they have decided that the third highest bidder, me. So therefore, notice of acceptance was issued to me, directing me to deposit the documents. But the Honorable Single Judge has held that my tender was defective. It is it did not contain all the documents. This very clause itself makes the submission of the other documents as directory, and that will be considered only in respect of when the highest bidder is when he emerges as the highest bidder. Then only he will be given an opportunity of 3 days time to deposit all the documents, and that's what the authority has done. So absolutely no illegality as such has been done by the standing committee in selecting me. But this court, Lordship has seen mainly on the ground that the amount was his amount was higher, and then secondly, that I have been certain documents were not with my tender, and thirdly, the application dated 15/7 was not before the standing committee on 14/7/23. They could not have taken a decision on that. Therefore, at this stage, I pray that the appeal may can be admitted. And not only that, this single judge, has ought to have been confined, with the decision-making process. But here you also will find, the court has, directed the authority to, settle the market with him for the remaining period, subject to payment of the remaining keys. The question of deposit of keys money, then the other documents entering into agreement, etc. All these things have been waived as a settling authority.
This stage, you also notice me go.
You are appealing for?
Appealing for the PNR, you also.
I'm actually a settlement holder. I'm still holding the market. It has not been taken away as such.
I am appearing for respondent number 124, Your Lordship.
But Mr. PG Cycle and senior counsel, assisted by
AM Khan.
then counsel for the appellants. Admit Mr. K. Conwell and the additional AG Assam appears for the respondents 1, 2,
3 and 4.
3 and 4. Stop. Appellants to take steps for service of notice on respond number 5 by registered post AD.
As well as by Dusty equipment.
Within 1 week from today. Stop. Additionally, appellant is also is permitted to close service of notice on the respond number 5 by Dusty service to the registry of this court within a period of 1 week. 1 week. Thereafter, appellant shall find an affidavit to that respect. Stop. List after 4 weeks. 4 weeks.
In the meantime,
Parties are directed to maintain status quo as on today.
in the meantime, the operation of the judgment may can be stayed.
No, Your Lordship.
I'm thinking to maintain status quo as on today.
Your Lordship, the judgment was given on 2012, Your Lordship. So more than 1 month. Possibly already some development is already.
That's why I'm saying status quo.
Yes.
Yeah,
That will-
Well, we have said the position of the market has not been handed over.
That's why if you have not handed over, it will be status quo as on today.
Obliged.
Item 14.
Milord, with due apology, Milord, I was supposed to file an affidavit clarifying the position that the degree obtained by the petitioner or appellant is correct or not, valid or not. Milord, I have received half instructions, Milord. So I am in difficulties to prepare the affidavit. Milord, if Lordship considers it appropriate, Milord, can it be taken up later on, granting some more time?
Milord, whether half or full instruction. Milord, I'll
Yes,
just,
yes, no
just
instruction.
place one paragraph, my lord, your lordship, just hear me. It's settled law that the principles of estoppel and res judicata are based on public policy and justice. Doctrine of res judicata is often treated as a branch of the law of estoppel, so these two doctrines differ in some essential particulars. Rule of res judicata prevents the parties to a judicial determination from litigating the same question over again, even though the determination may even be demonstratively wrong. When the proceedings have attained finality, parties are bound by the judgment and are stopped from questioning it. They cannot litigate again on the same cause of action, nor can they litigate any issue which was necessary for decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. Now, therefore, my lord, in the earlier occasion, the Reed court, my lord, they did not contest at all. They did not file any affidavit. And here, whether it can be really litigated. My lord, the Supreme Court has very clearly, and there are so many other decisions also. So therefore, my lord, I don't think they are entitled to file their affidavit at this stage.
No, Milord, it is not at my fancy or whims, Milord, that I wanted to file an affidavit. It's an order passed by this court, Milord, and I have to oblige to the order of this honorable
Well,
court.
order passed because of their pair only. And
But there is
whether,
an order, but the fact remains there is an order.
whether in view of the
Whatever
judgment.
it is, one order was passed.
Yes, Milord.
But that was on your request.
Yes, I understand, Milord, but it pertains to the.
Why are you taking so long?
My lord, I am sorry for that, my lord. I did not receive the proper instruction. I received, but it is not proper. So I am not in a position to prepare it. Now, my lord, this is the last chance the lordship is giving us, if lordship is at all pleased. My lord, why I am praying so? This is a matter pertains to the public policy. It's a maintenance of standard of higher education in the country.
That's why you should hurry up in filing.
My lord, my lord. I am bowed down to your lordship, my lord, words. My lord.
Okay,
My
so
lord,
last chance.
even in such circumstances, my lord, if your lordship finds that the affidavits are all unnecessary, your lordship may pass an order of compensation. My lord, Supreme Court in such circumstances compensated the parties up to 10 lakhs. So my lord, you will have to take that responsibility.
No, this is unheard of, my lord.
Not unheard of. Supreme Court has said, it's not my version.
This is unheard of.
But I can,
Mr. S. Datta, Learned Senior Counsel, assisted by Mr.
Yes, sir.
S. Datta, Learned Counsel for the appellate. Stop. Also heard Mr. K. Gogoi, Learned Standing Counsel, Higher Education Department. For the respondents, 1 and 2. Mr. A. Chamwa, Learned Standing Counsel, UGC. Submits that, that he has received some instructions. However, he requires some more time to file an appropriate affidavit. Stop. Accordingly, comma. How much time? 2 weeks.
My lord, this will do, my lord.
Time as last chance is given to the respondent number 12 to file affidavit in terms of the order dated 4/12/2023. In terms of this court's order, 4/12/2023. List on 5th.
whether Justice Ate will be there on that day.
Shall we release it from parted then? Or we'll keep it as parted?
For 2 weeks, your lordship, keep it as parted.
As parted.
Public.
Item
Lordship, I
32.
fix it on 5th of February.
Yes. On that day positively.
No, no,
declared,
5th of the time,
will dispose of
5th of
this.
the time.
32.
Madam Lordship,
Shall we
Lordship,
take a
my
break?
prayer is very simple, Lord. Yes, Lord, yes. Prayer for only the interest portion, Lordship. So I have received the principal amount, Lordship, which I have stated in para number page 7, Lordship. The brief of the text, Lordship. Page 7, Lordship. So my land has taken in the year of 2001, Lordship. So land measuring 4 bigha, 15 less or something, Lordship. So I have received the amount, Lordship, 86 lakh 13,600 in the year of 2022, Lordship. So as per the provision, Lordship, is the new Fair Act, Lordship, is after actually the 5 years, Lordship, is ought to be the new Fair Act, Lordship. So that is the section 80, Lordship. The right to fair compensation, Lordship. Is section 80, Lordship. The right to fair compensation and transparency, land acquisition, rehabilitation and resettlement act 2013, Lordship. Section 80, Lordship. It's a statute law, Lordship, absolutely. Section 80 is clearly defined, Lordship. Very, Lordship. Section 80, Lordship. The payment of interest.
1
Lordship.
minute.
When the amount of such compensation is not paid or deposited on or before the taking possession of the land, the collector shall pay the amount award with interest thereon at the rate of the 9%. per annum.
Section?
At the rate of 9%, Lordship.
Section.
Section 80, Lordship. The new Fair Act compensation. 80, Lordship. It's a statute law, Lord. Merit, Lord. When the amount of the such compensation is not paid or deposited on or before taking possession on the land, the collector shall pay the amount award with interest thereon at the rate of 9% per annum for the time of the taking possession until shall have been also paid of the deposited. The provided, Lord, you can define, Lord. The such compensation or any part of thereon is not paid of the deposited when within the period of the 1 year from the date of the which the possession is taking interest at the rate of 15% per annum shall be payable from the date of the expiry of the said period of the 1 year on the amount of compensation as part of the which has not been paid deposit therefore before the date of the such expiry lot. So amount received lot say I have on 12/2018 lotship, which has already exceeded the 5 years lotship. Section 24 lotship can be filed. Section 24 subclause 2 lotship. Section 24 subclause 2 lotship. Married lot can be filed. It's in new act lotship. Section
Yes.
24. And notwithstanding anything contained in subsection 1 in case of the land acquisition proceedings initiated before the Land Acquisition Act 1894, for an award under the said section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken, or the compensation has not been made, paid to the said proceedings shall be deemed to have lapsed, and the appropriate government, if it is closed, shall be initiated proceeding of such land acquisition phase according with the provision of this act. So if the exceed the 5 years on that way, the new act will be applicable, lordship. So here, lordship, the learned single judge paid only the principal amount, lordship. The imping order, lordship, kindly find, lordship. Page 112, lordship. One and two, lordship. I'm sorry for 111, lordship. 111, lordship. Property purpose. The
It's under the Act of 1964, isn't it? Your land was acquired under the Act
Yes,
of
lordship.
1964.
1964. 1964, lordship, and that had already, after notification, if exceed the 5 years, the section 24 wise, lordship, the new act ought to be applicable, lordship. The new Fair Act, lordship.
No, lordship, in 1964 Act, there is also a provision for an compensation, lordship. That it is under section 12 of the Act, lordship. It's clearly written. The application has to be submitted before the concerned deputy commissioner, lordship.
On section 12 says, lordship, the deputy commissioner only finalization the award, lordship, and that part already over, lordship.
Where's the section, where's 64 Act? Is it here?
Section 12 is lordship. Page 419. Volume 30. 13.
So here, lordship, the section 12, 1964, lordship, which is clearly defined award of collector when to be final, lordship. This book, lordship, which is clearly defined, lordship, is a 1964, lordship, land acquisition and requisition, lordship. So here, lordship, award of collector when to be final, lordship. So whereas the exceed the 5 years, so if 5 years exceed the section 24, which is clearly defined, lordship, the new act of you applicable, lordship. So learned single, which is clearly defined, lordship, the page is a one judgment, lordship. Page 105, lordship, the learned single the himself admitted, lordship. 105, lordship, can define, lordship. You kindly find 105.
1 minute.
Yes, sir.
When did you get your compensation?
Lordship, is a 2024, lordship. December of 2004, 24, lordship. The last year, lordship. 23, lordship. 12/12/2023, lordship. Last year. the month of December, Lordship. And my land was acquired in the year 2001, Lordship. After 22 years, Lordship, I have received the amount, Lordship. And the section 80, which is clearly defined, Lordship. The first year, 9% interest, and another after exit of 1 year, the 15% ought to be interest from the principal amount, Lordship. And the learned single judge only given the principal amount, Lordship. And the interest portion hasn't been reflected, Lordship. So, Lordship, kindly find, Lordship, case 105, learned single judge himself stated, Lordship. 105 in my read-appeal petition, Lordship. 105, Lordship. Kindly find out. The learned single judge, which is clearly defined, Lordship, in as much edit, Lordship, is a second paragraph, Lordship. 105, Lordship, please. Internal press of the judgment, Lordship. Order dated 9/10/2023, Lordship. 105, Lordship, can you find? Para number 5, Lordship, the bottom, Lordship. From perusal of section 11, Lordship. May I read, Lordship? From perusal of section 11 of the Assam Land Acquisition and Requisition Act 1964, it is stipulated that the compensation would be paid in terms with the Land Acquisition Act 1894 subsequently in view of the notification which has been issued by the Revenue and Disaster Management of Government of Assam. It is stipulated that the compensation would be paid in terms with the right of fair compensation and the transparency in Land Acquisition Rehabilitation Resettlement Act 2023 in respect of the acquisition made under the Act 1964, Lordship. So, learned single the same shall state, Lordship. And next para, Lordship, 6, Lordship. In the both the land acquisition, in both the Land Acquisition Act 1894, as well as the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act, the interest to be paid is 9% on the compensation amount from the date of the taking over the position for the first year, and thereafter at the rate of the 15% after completion of the first year. It is known, it is not known as whether the said interest has been calculated in the proposal submitted by the respondent by the Deputy Commissioner, Dorong, but taking into account that the interest amount would to be for period of the 20 years, Lordship. And the market value has been assessed at rupees 20 lakhs per bigha, Lordship. So, learned single judge himself stated, Lordship, in this regard, Lordship. So, new fair act ought to be applicable, Lordship. If the new fair act applicable on that section 80, clearly hit, Lordship, is a interest portion ought to be required, Lordship. Lordship, Honorable Supreme Court railing on judgment, Lordship. Is a Monohar case, Lordship. Is a full bench judgment.
Lordship, my learned friend has challenged the order dated 18/12/23 passed by the learned single judge. In this judgment, learned single judge has rightly stated if anything is there, then under section 12 of the 64 Act, he is at the liberty to oppose the.
Which the 64 Act?
Lordship, the Honorable Supreme Court clearly defined one judgment.
And if your Lordship.
This section 24. This one is.
Monohar, 2000 feet. 2000 feet. 1 to 9.
Yes.
Lordship,
Honorable Supreme Court held one of the
one
judgment
more
lordship.
submission, Lordship. The order passed by the learned single judge is on 18/12/23. This order has been challenged. And in this order, there is specific that the petitioner has to approach the deputy commissioner. Instead of approaching the deputy commissioner, what my learned friend had stated in page 113, he has written a letter to the honorable single judge for calculating the interest portion. It's there only, page 113.
Section
On the
12
same date.
Section 12 is not applicable as because in the section 24 hit by in this new Fair Act lordship, after exceed the 5 years, it ought to be applicable to the new Fair Act lordship. Section 12, that part already over lordship. And the new act ought to be applicable lordship. Section
What is
24.
this annexure E?
Annexure E lordship is a calculation lordship, interest portion lordship. And during the final hearing, so I have submit that particular.
How dare you write to the judge like this?
Lordship, as per the instruction of my client lordship, so interest portion ought to be entitled lordship.
So you wrote to the judge.
I'm sorry for
You
that.
wrote to the judge.
I'm sorry for that, lordship.
I'm not asking you whether you are sorry or not. I'm asking you a question. You wrote to the judge. Correct?
No, on
The
the hearing,
council wrote to the judge, correct?
that application on the hearing ground has submit lordship for the calculation of interest portion. lordship. I'm sorry for that, lordship.
The bill has to be dismissed. Lordship.
Lordship, as for the
Yes.
so as per the convening of the honorable court lordship, so that's why lordship, that application is submitted. Lordship, I'm sorry for that, lordship, and that part ought to be the delayed lordship, is the calculation part.
I'm not talking about the calculation part. I'm just talking about your propriety to have written to the judge yourself, isn't it?
As per the instruction of this, my client. lordship.
Are you to instruct your client or the client is to instruct you in such matters?
I'm sorry for that, lordship, and that
No,
part,
no,
the calculation
I'm
part.
sorry.
Lordship, I may allow, and that case has to be delayed, lordship, the interest portion, lordship. So as far as the state law, lordship,
You withdraw this or we're dismissing it?
I will allow to withdraw, lord. With
Is
liberty,
that-
lord.
No liberty.
Lordship, I'm sorry for the lordship, my
Your
client,
good
lordship,
name,
Archidas.
Archidas, General Counsel for Petition, appellant. Praise for withdrawal of this great appeal. Mr.
RM Das.
R.M. Das, Leonard.
Water Resource, Standing Council,
Standing
Water Resource.
Counsel, appears for the Water Resources Department and Mr. M.S.
And Portman for respondent number 1.
Government Advocate.
I'm standing counsel deputy.
And 1 minute, and Gotulio, Leonard Standing Counsel Revenue for the respondents 1 and 2. And MS Bora, then Government Advocate for respondent 3.
Lordship,
Writ appeal is
so the
dismissed.
appealant will be agreed, lordship, as because lordship, interest portion hasn't been received, lordship.
You
On that part,
proceed according to
so I may
the,
allow to liberty, lordship. I'll file a fresh petition, lordship. Lordship, we do respect, lord.
what fresh petition?
The fresh appeal will be filed, lord.
No.
On that part, I'll be delayed. I'm allowed to liberty, lord.
You proceed according to the single judge.
Item 34. Section 12 is not applicable, lordship. Section 12 is not applicable, lordship. Yes, because section 24 will clearly hit, lordship.
Why didn't you write to the judge that section 12 is not applicable? Why did
Lordship,
you
the
write,
section-
why did you write only for enhancement, only for the interest portion?
Lordship, the section 24, which is clearly defined, you exceed the 5 years of the, on that way the new.
You can
act-
write to the judge with regard to the interest portion,
Interest
calculation of interest portion. Why couldn't you write that section 12 is also not applicable?
Lordship, on the notification, which is clearly defined, lordship.
Or you can file a review application.
Yes.
Okay, on top you say, praise for withdrawal of the with liberty to file review petition. Huh? And then the rest will be same. This appeal is dismissed on withdrawal with liberty as put.
Mass of
You be
Item
more
30
careful in future.
Yes, I'm
Or
sorry
else
for that.
Write to the bar
Yes, yes.
council for suspension of your license.
I'm sorry for that.
34. Wait, please. Your Lordship, the impugned order is at page 9, Your Lordship. The case here pertains to compassionate appointment.
Page?
Page 58, the order starts, Your Lordship. The contents of the order starts at page 59. 59.
Yeah.
If I may be permitted to submit from paragraph number 2, Your Lordship. Facts have been laid down. If I may be permitted to read, Your Lordship.
Yes.
Yes. The case of the petitioner is that her father, namely late so-and-so, has died in harness on 17/6/2003 while serving as assistant teacher at Pamundoloni ME School under the jurisdiction of District Elementary Education Officer, Lakhimpur. It is projected that in the same year, the petitioner had applied for appointment on compassionate ground in the prescribed format. It is also projected that by a forwarding letter dated 18/4/2005, the application of the petitioner was forwarded to the competent authority for considering her appointment on compassionate ground, and in the said list, the name of the petitioner appeared at serial number 31. In the particulars forwarded by the DEEO, the name of the petitioner appeared at serial number 8. It is the case of the petitioner that till 10/4/2012, the application of the petitioner was not considered, and thereafter, the Deputy Commissioner Lakhimpur issued a letter dated so-and-so to the DEEO, who had forwarded the list of pending applications where the name of the petitioner appears as serial number 70. The petitioner has not been informed about the status of her application for appointment on compassionate ground, and accordingly, this writ petition has been filed under Article 226 of the Constitution of India. The learned counsel for the petitioner has submitted that pursuant to the order dated 10/2/2023, she has filed an affidavit to bring on record the statement regarding the post which was held by the father of the petitioner. It is also submitted that in terms of the OM dated 1/6/2015 in respect of appointment on compassionate ground, it was incumbent on part of the DLC to consider the candidature of the petitioner for appointment in any suitable grade 3 or grade 4 post, and in this regard, she relies on paragraph 15 of the said OM. The learned counsel, standing counsel for the Elementary Education Department, has produced a copy of instructions to project that the name of the petitioner was forwarded on 18/4/2005 by the DEEO, and it is submitted that the OM dated 10/1/6/2015 would not be applicable for the petitioner as her father had died in the year 2003, and during that period, the OM dated 9/9/1983 was applicable for the petitioner. It is also submitted that as per the decision of the case in the case of Osud Ranjan Das versus State of Assam and others, the applications which are not considered for 2 years are deemed to have spent its force as per paragraph 10 of paragraph 7 of the said decision if the application of eligible candidate remain pending and cannot be considered due to want of vacancies for a period of 2 years. From the date of making such applications will require no further consideration and must be understood to spend their force. Having considered the materials available on record, the court finds that the application of the petitioner for appointment on compassionate ground, which was submitted in the year 2003, had been duly forwarded by the DEO by way of forwarding letter dated 18/4/2005, wherein the name of the petitioner appears at serial number 31. This is the gist of the matter, Your Lordship.
Yes.
Yes. Now, I pray Your Lordship comes to page 50, which is the OM, Your Lordship. Page 50. Page 50 is where the OM starts. Yeah, 5. Your Lordship has that. Yes. Now, Your Lordship will kindly come to page 56, which is a clause 24A. Clause 24A, page 56, Your Lordship. Your Lordship has gotten page 56.
Yes.
Yes. As regards pending cases prior to issuance of the direction in Osud Ranjan Das versus State of Assam, that is 3rd August 2006, the authorities departments need to ensure that compliance of the directions contained in Principle 1 urgently. The High Court has fixed 30th September 2010, within which all such pending cases were required to be considered. Those departments which have not yet complied with Principle 1 and disposed of all such pending cases shall complete it within 6 months from the date of issue of this OM. Your Lordship, Principle 1 Principle 1, Your Lordship, is at page 53. Page 53. Page 53 is the Principle 1, Your Lord. If I may permitted to read, Your Lord. All pending applications against existing vacancies as per the quota earmarked, including the cases of the petitioners in the present cases and all others who may not be before the court, shall be decided in accordance with the proposed directions to be laid down in the present order and also in accordance with the principles noted in the preceding paragraphs of this order. This will be done within a period of 4 months from today. The present direction naturally has to be considered as a one-time measure in view of the subsequent directions as laid down in the succeeding paragraphs. The application, Your Lordship, the application of the applicant, of the appellant was forwarded in the year 2005, which was before the order of this Honorable Court in Achut Ranjan Das. So Principle 1 has to be applicable in this matter, Your Lordship. My case here, Your Lordship, as has been projected in the writ petition, is for absorption by the SLC, but that cannot hold water before this Honorable Court, Your Lordship, that the SLC, the mandamus cannot be issued. What I pray for, Your Lordship, is that pursuant to the Principle 1 and Achut Ranjan Das's order by this Honorable Court, Your Lordship, the petitioner be kindly intimated whether her case was put forward before the DLC or not. The order which is before Your Lordship, which is order dated 2005, it was forwarded by the DEEO to the Deputy Commissioner Lakhimpur. Thereafter, nothing happened. Subsequently, in the year 2012 also, which again, it's a carve out to the OM dated 2015, her case was again considered. The impugned order reflects two separate dates, 2005 and 2012. The appellant was not intimated. Now, this is not my case that I have to be absorbed or I have to be considered against a vacancy which arises at that point in time that may not hold water before this Honorable Court. At this point, Your Lordship, my limited prayer before this Honorable Court is that the appellant may kindly be intimated whether her case was considered or not, subject to the applicable regulations at that point in time. Thereafter, there might be a separate cause of action which might pertain me to approach this Honorable Court again, subject to Your Lordship's final observation. But this is my limited case here, Your Lordship. The 2005 OM was bought.
Your case was dismissed on the question of delay only.
Yes, it was. Yes. It was considered on the aspect of delay by taking into account the decision of Achut Ranjan Das read with the OM date 2015. In light of these observations by this Honorable Court, paragraph number 6 at page 61 states that the petitioner has approached this court after 19 years. I have approached this court after 19 years, but my case initially was considered prior to the cutoff date which was given in the OM. My case was initially forwarded in the year 2005 and subsequently it was also forwarded in the year 2012. This is my limited expectation from the government that I at least be intimate. Adversity, financial adversity, Your Lordship, I have not seen somebody go up the scale of financial ladder, Your Lordship, in the life. That is my only case.
See, whether your case was considered or not at that relevant point of time.
Yes, if it was, then
If it was, or even if it was not.
Yes.
You have approached the court in 2022 only.
Yes.
So what difference would it make? Whatever they say.
So, Your
In
Lordship,
any case, the delay is already there.
the delay is the, Your Lordship, the delay here.
Whether you were considered properly or not in terms of the
Yes.
OM.
Yes, in fact, Your Lordship, Your Lordship is very correct, Your Lordship. In fact, what has happened here,
It would make a difference.
there are judicial discipline in place which I cannot object to, Your Lordship, but it does make some sort of a semblance of a difference to the appellant, Your Lordship, who's still aggrieved to the extent that her case might not have been considered. That is the extent to which I am before Your Lordship. The writ petition prayed for absorption by the SLC. I cannot pray for that in the light of judicial discipline of this Honorable Court. I cannot ask for that. That will be unreasonable for me as a counsel to also argue before this court. What I'm merely seeking, there is a delay. I cannot dispute that as 19 years, but the 19 years of delay has been taken into account looking into the fact that the 2015 OM strictly deals with the fact that my cases have had to be considered within 2 years. Whereas 2015 lays down that Achut Ranjan Das will not be applicable in my case.
Because It don't make a difference, Mr. Sharma. Yes, Madam.
That is what I was about to also point out. 19 years she resigned to her fate that her application had not been decided, or she doesn't know the fate of her application. In the morning, my lord, she started to say that I need to know what happened to my application. Attitude itself shows whether she was actually pursuing or was interested in pursuing the matter.
Financial adversity.
Those were the days, my lord, when the Achyut Ranjan Das case and judgment came, or when the 2015 judgment came, my lord, that was an era of compassionate appointment being dealt with by this honorable court in huge numbers. She did not even feel it necessary to come at that point of time also. But after 7 years after that, she waits. And at this point of time, a consideration on compassionate appointment after all the law has changed.
I'm not asking for any consideration. I just,
You're not
subject to what
pouring
your
very
lordship
much
is,
statement.
subject to my learned friend's submission. I only need to be intimated whether my case was put up or not. That is all that I'm seeking.
Whether even if you are intimated or not, they don't make any difference.
What I
now.
understood from his arguments, my lord, that once the intimation come, I may have a ground. That
I
is
may,
what
I
that,
may.
that,
That is
that- so that would again lead to a fresh litigation, fresh cause of action, prolonging a same.
I'm standing on a very narrow.
Yeah, we see
Okay.
nothing wrong in the judgment.
In fact,
very much clear.
no, what was
So they-
relied on by this honorable court, what was relied on by this honorable court in paragraph number 4 was that an earlier OM would be applicable, which is dated 1983. What I'm striving to show your lordship is that the 2005 OM itself is applicable because they've made a certain carve out for matters which are pending before the Achyut Ranjan Das came into play. And there is a subtle there's a detail here that your lordship would like to see into your lordship. If your lordship can kindly come to principle. Yes, page 48, your lord, page 48.
See, your case was forwarded on in the year 2005.
And thereafter in 2012 also, your lordship. That is why I'm striving to point this out before your lordship. If
So
your
in
lordship can-
2012 also, but then this OM is of 2015.
Yes.
It does not have retrospective effect.
No, it says here, page 48, for a moment, your lordship. Just for a moment, your lordship.
Page 48.
Page 48.
What?
Page 48. Page 48, 24A.
Hmm.
I'm reading this again, your lordship. As regards pending cases prior to issuance of the direction in Achyut Ranjan Das and others versus State of Assam, the authorities departments need to ensure that compliance of the directions contained in Principle 1 urgently. The High Court had fixed 30th September 2010, within which all such pending cases were required to be considered. If 2010 was the cutoff date for requirement, then the appellant's case, which was also forwarded in the year 2012, also merits some rebuttal from the other side. Subject to your lordship's convenience. I mean, the petitioner is standing on financial adversity. There's nothing else. And that is the only limited prayer with my folded hands I approach his honorable
19
court.
years, 19 years, 20 years, you've been able to outstand any type of difficulties. Now, there's no point of coming before the court.
The mandate in place also, but my submission is strictly on the observations of this learned single judge. If the lordship finds that there's some merit, then mere intimation of the fact that whether it will provide some solace to somebody who's already at the lower end of the financial ladder, your lordship. There's nothing I cannot even claim. The petition, the writ petition claim for absorption by the SLC, that I cannot contend and submit for this court. That will not be a proper submission from an officer of the law. But what I submit, your lordship, before this court, that the case was considered in 2005 and also 2012 separately. The names are forwarded. Whether it was considered or not, that might merit some indulgence from your lordship.
But they can stick to RTI also.
Or the state which is sitting over it. There's some duty towards applicants, some duty, some minimum level of duty that the government has.
There's nothing you can do there. What he's saying is correct. You can have filed through the RTI and get your instruction.
I chose a harder way to approach this court and get an order from this honorable court, which I failed, your lordship. But the government can
That
please.
will not be possible. We see nothing wrong in this order.
This is my limited submission that I was making, based on the fact that the OM was looked into and the Othutandan Das was also looked into.
You also bit sorry, but the law does not prohibit the inordinate delay. Not 19 years.
But Mr.
M. Sharma, Your Lordship.
M.
The delay
Sharma,
should have been 10 years, not 19 years, because 2012 was the last occasion when the candidature of the. Yes, then also, yes. Then also, I'm sure, but it's not 19 years, it's 10 years. 2012 was the last occasion where the appellant's name was forwarded.
Learned counsel for the appellants also heard Mr. Endas, Learned Government Advocate for respondents 1 and 4, and Mr. R. Majumdar, Learned Standing Counsel,
Department of School Education.
Department of School Education for respondents 2, 3, and
2
5.
and 3. 5.
Stop.
5.
The case of the petitioner, the case of the appellant, in brief, is that her father, late Hitish Moran, while serving as assistant teacher at Bamundulani MA School, died in harness on 17/6/2003. Stop. The appellant in the same year, i.e. 2003, applied for appointment on compassionate grounds before the appropriate authority, competent authority. Stop. The application of the petitioner was also forwarded to the competent authority by letter dated 18/4/2005. And in the set list, her name appeared as serial number 31. Stop. The case of the petition and the case of the appellant is that her application was not considered till 10/4/2012. And thereafter, the Deputy Commissioner Lakhimpur issued a letter dated 7/4/2012 to the District Elementary Education Officer What is in this letter? 7/4/2012.
7/4/2012 is the forwarding of the candidature of separate applicants, Your Lordship. My name features under serial number 70. My name features at page 37, Your Lordship. Page 37, serial number 70. The fourth name from the top.
7th of April is the letter asking for details. These details were forward at page 33.
34. Sorry.
7/4 is the letter asking for details of pending application.
Where is that letter?
Page 33, letter dated 7/4. 2012 is a letter asking for the details.
Oh, no. Just say. The Deputy Commissioner Lakhimpur, huh? By letter dated 7/4/2012. And addressed to the District Elementary Education Officer, Lakhimpur. South. No, requested to submit a list of applicants who had applied for appointment on compassionate grounds since last 5 years. Stop. Consequently, by letter dated 10/4/2012, the District Elementary Education Officer, Lakhimpur, submitted list of applicants for appointment on compassionate grounds to the Deputy Commissioner, Lakhimpur, wherein the name of the petitioner, the name of the appellant appeared at serial number
70, Your Lordship.
70.
70.
Stop. As the case of the appellant was not considered for a considerable period of time, she approached the writ court by filing WBC number
7917
7917 of
2022.
Stop. Which was disposed of by order dated 21/4/2023, holding that in the light of decision in the case of acute Ranjan Das versus State of Assam and others, within bracket 2006 4 GLT 674. The petitioner has approached this court, had approached the court after 19 years for enforcement of a right to claim appointment on compassionate grounds. Stop. Accordingly, in view of the inordinate delay in approaching the court, the writ petition was dismissed. Stop. Para. Being aggrieved, the present writ appeal. Para. Then the counsel for the appellant submits that the petitioner at least has to be intimated whether her case was considered in the year 2003 for appointment on compassionate grounds by the concerned district level committee. Is that DLC, isn't it?
Yes, Your Lord.
By
The
DLC.
Deputy Commissioner is the chairman also.
Stop. He submits that in terms of the office memorandum, dated where's that memorandum?
16,015, Your Lordship. It is at page 50.
Dated 1st June 2015,
Yes.
issued by the Department of Personal B, Government of Assam. The petitioner, the appellant, where was that? You are relying on which one?
24A is at page 48, Your Lordship. Page 48.
That the appellant.
Yes.
In terms of clause 24 within bracket A, has a right to be considered for appointment on compassionate grounds. And therefore, and also has a right to know whether her case was considered. Stop. Para. After hearing the learned counsel for the parties, we find that the appellant had met her application as early as in the year 2003 for appointment on compassionate grounds. Thereafter, no steps were taken by the appellant with regard to her status as to whether her case was considered by the concerned DLC or not. Stop. It is only in the year
2022.
2022, that she approached the learned single judge by way of filing WBC 7917 of 2022, which was rejected on the grounds of delay. Stop. Para. Coming to the submission of the learned counsel for the petition for the appellant, that the appellant has a right to know as to whether her case was considered in the year 2023 or 2025. We are of the considered opinion that even if her case was considered in the year 2023 or 2025, it would make no difference inasmuch as there's already an inordinate delay on the part of the appellant in taking appropriate steps for adjudicating her rights before the competent court. Stop. In view of the in that view of the matter, comma, we have the considered opinion that there's no merit in the present appeal, and the same is accordingly dismissed. No cause.
My lord, item 47, can it be fixed up on 30th?
Okay. Year 40?
7.
47?
Yes.
Year 40?
I'm for the appellant.
Okay.
On 30th.
Okay, on request made by the parties.
My
Please
lord,
start.
item number 48 and 49, my lord. Can it be taken up on 25th, my lord? I have informed the other side, my lord.
Okay, on request made by Mr. James Chowdhury. Please stop.
On 25th, no.
25th.
On 25th. Bye.
Vishwakarma. Yes, Vishwakarma, learned counsel for petitioner, as well as Mr.
It's not.
It's not for the respondents. One, two,
Right.
hearing concluded, judgment reserved. Yes.
Item 2.
I'm filing petition.
We have already earlier filed on 9/8/22.
You're Mr.
A Bhattacharjee, my lord.
A. Bhattacharjee for the petitioner, Mr. R. Majumdar. You're the standing counsel
For the Duke University.
or standing counsel, Dibrugarh University. Same order.
Obliged.
Item 3.
Lordship, taking time for 1 week to file written argument. I'm on behalf of the petitioner,
Your good name?
A Banerjee.
On request made by Banerjee, learned counsel for petitioner, list the matter again on
1 week time.
1st February.
Item 4.
With your lordship, I'm submitting this written argument, my lord.
With my response of
Obliged.
3 and 4, I'm submitting.
But Saikia for petitioner and MS Bora, no? Government advocate,
Standing counsel petition.
standing counsel BTC for the respondents. 2,
2, 3, 4.
2, 3, 4, and Mr.
D. Gugumel.
D. Google for the respond number
5 mile.
5. Same order.
Item 5.
Obliged.
Lordship, if I may point out, Lordship, our lien ends at the end of this month.
You've submitted your
Yes, my lord.
10 Gautam, learned counsel for petitioner, and MS
R. Barua, my lord.
R. Barrow,
For the
learned
state of Assam.
for
For the state of Assam.
for the government advocate.
Yes, my lord. KHSU, my lord. Krishna Kanta University.
Same order.
Item 6.
My lord, I'm submitting a written on behalf of the petitioner. My lord.
I am submitting written argument on behalf of respondent number 6.
6. How about the other respondents?
We are the cottages,
What is it?
we are the cottages, my lord. Property for the
I am the principal respondent, my lord.
But Mr.
Yes, Hazarika, my lord.
Sazarika.
My lord, I'm lead by Ranjit Senior Counsel I Chaudhary.
Heard I. Chowdhury, learned senior counsel. Assisted by S. Hazarika, learned counsel for the petitioner. Also heard Mr.
J.
J.
Patel.
Patori, learned counsel for the respondent number
6.
6. And Mr. B. Bharadwaj for respondents. 3, 4, 5, 6, 7. Same order.
6 I am appearing, my lord.
3, 4, 5, and 7.
Deeply obliged. Item 7, 8, and 9.
You have 40?
Petitioner,
MS?
M. Zomonpui. I'll write it down.
And Mr.
M. Islam for respondent number 7 in WPC 5231, item 7.
How about the Barbujari? How about the other respondents?
I'll inform my for Pujari for respondent number
He is the main respondent here.
I'll inform him.
Okay, we'll list it on Monday, 29. Okay, cancel it. You take back your arguments. You submit it on Monday. Okay.
Highly obliged, Your Lordship.
On request made on behalf of our board, list on 29th.
Item 10, 11, and 12.
My lord, item number 10 and 12, my lord, we are yet to file a written argument, my lord. So, my lord, will kindly give us 1 week time. And in item number 11, we have already filed a written argument.
Okay, that you do later. On request made by Mr.
K. Mohammed.
K. Mohanda.
Mohammed.
Mohammed. Learned counsel for the petitioners. List down. When? After a week?
Next week, yes, sir.
1st February?
1st February.
Item 13. Obliged.
Please, Lordship, kindly pass over the matter for the time being.
Why?
My senior is on court at court number 13.
We're at the end of the board.
This is review petition.
Oh, review.
Both sides pleadings have been completed, madam. So, thought that may be fixed for admission hearing.
Pleadings are complete, though?
Completed, madam.
When do you want?
Not within a week, madam. 1st of February.
Okay. Okay. On request made by the parties, list on 1st.
Item 14.
I have to submit prayer, Lordship. As per office note dated 23/11, the respondent has left his home address. So maybe allowed to take step on his new address.
You got the new address?
Yes. He has shifted to his hometown at Orissa.
At?
Orissa.
What, Mr.?
AM Doctor.
A.M. Datta, learned counsel for the petitioner. Stop. Learned counsel for the petitioner submits that the respondent number,
So respondent.
that the sole respondent has shifted his residence, and they have got the correct and proper address of the sole respondent, and therefore prays for taking first steps for service of notice on the sole respondent by registered post.
By
By registered post.
3 weeks, Your Lord.
Within a period of 1 week. 1 week?
2 weeks, Your Lord.
Within a period of 2 weeks from today. In the new address. Stop prayers allowed. Least after 4 weeks.
This is some unusual prayer routine, item 4, Lordship, fixed the date on 1st of February. May I pick, can it be on taken up on 7th or 8th? I'm not responding.
That is Pier 4.
4.
Pier.
Is it? Okay.
Why? You want something?
Yep. Yes. We want some time to submit or return it.
Okay.
Because you have
Item 4.
4.
Then heard MSN Psyche. Then what did I say? Protocol also, no? This 1-5. You are appearing for?
For Mr. PD Nair, extending counsel from Cotton University. Correspondent for
On request made by on behalf of Mr. P.T. Nair and standing counsel, Cotton University. When do you want?
8 or 9. It is fixed on 1st of February.
Uh,
So it may be fixed, it may be on 8th of
8 February.
Okay.
Item 36 for orders.
May please your lordship. This is with regard to the construction of the retaining wall at Malibagan, Lord.
1 minute.
Pursuant to lordship last order, the committee has set up and before the committee, the officers of the PWD they appear. Finally, some resolutions have been taken and this is the communication they have. Okay.
So when are you starting your construction?
Well, the report, possibly the report of the building committee is also available for your.
Oh, the thing is there before us.
The committee has approved.
Hmm.
Now, Mullah, lordship may give us some time. Let me have the plan and how they will proceed. I'll let you.
May please your lordship. I have a humble prayer, my lord, that this matter may be taken up fortnightly so that the honorable court can review the progress.
Year 4?
I am appearing on behalf of Mr. H.K. Das, standing counsel of this honorable
name?
court. I'm U. Pathap.
Mr.
I'm appearing for the private. We are staying behind that road. We are the permanent residents that already one and a half year.
Yeah, I'm giving him 2 weeks time.
Yeah.
U. Pathap.
Then council appearing on behalf of H.K. Das. Learned counsel for the applicant, stop. No, learned counsel for the petitioner. Stop. Peruse the minutes of the Committee for Building and Infrastructure of the Honorable Guwahati High Court, which was held on 10/1/2024. Stop. Not stop, wherein the proposal to construct the road by using gabion, the casing instead of retaining wall was approved. Stop. Para. Mr. D. Nath, Leonard, Senior Government Advocate, has also produced a letter dated 18/1/2024, written by the Executive Engineer, PWD, within bracket roads, New Guwahati Territorial Road Division. And the relevant portion is extracted here in below. Para. Mr. D. Nath, Leonard, Senior Government Advocate, placed for some time to enable him to receive instructions as to when the construction is going to start, correct?
Malad, Lordship may kindly indicate that the committee has already approved that minute is not the minute of the committee meeting is not. Kindly indicate that.
Have you got the minutes?
Oh, we have one copy.
Okay. So accordingly, this the matter again on, give a date after 2 weeks.
8th of February.
8th
Lord,
February.
8th of
Registry is also directed to furnish a copy of the minutes of the Building and Infrastructure Committee of Guwahati High Court held on 10/1/2024 to Mr. D. Nath, Leonard, Senior Government Advocate, within the course of the
Deeply obliged, Lordship.
37.
I'm for the respondent.
Why is it coming for orders today?
My lord, because the TS case in title should, my lord, final order judgment passed by the deputy commissioner under the provision of the special state. When deputy commissioner passed the order, my lord, that time judice not separated from accusing. And the ad volume is 11,000. So as per High Court rule, my lord, if the amount is 10 lakhs mile or more, then matter will go to the division bench for.
Okay.
So CPC, my lord, is not applicable in case of Haflang, the letter of the
Spirit is applied,
only.
isn't it?
So when deputy commissioner passed the order, they have to prepare appeal before the division bench, which is to be listed as real appeal. Here, my lord, case they is that as regular fast. But it is not a regular fast appeal because they have prepared it as per provision of order 41 rule. So that provision is not applicable in case of Haflang because special statute says that as per rule 39, they have to prepare appeal before the High Court. So matter is to be listed for division bench for hearing with LCR.
LCS have come. Was it called for?
Record call for.
LCS? Only one LCR?
No idea, my lord. LCR call for.
What is the case number in the
06 of 2005. TS case, my lord.
Title suit number
06
of 2005.
6 of 2005.
It is already there, your.
Where?
The, court part. Because I have procured a certified copy for filing of this appeal.
Yeah.
This is only the miss case. This is only miss case, Mr. Gogoi.
When my lord, last occasion when matter has been listed, my lord, before the single bench, my lord, that time healthcare was with the record, with the appeal.
With your permission, your Honor. We have initially, after filing, after passing of the title 06 of 2018, your Honor, in that case, we both haven't, we both are in the half law before. Me and my Lanjana. Thereafter, we had filed a writ petition, your lordship. At page 52, if lordship permit me to go to my RFA, page 52. There is a judgment passed by the Langdon single judge, whereby the court has observed in the relevant portion at page 55. One single bench has been passed, an order has been passed. My learned senior counsel has pointed out that debts may be go to the Hill appeal. At the time of filing of this Hill appeal, your lordship, at the time, judiciary has not been separated from the executive. So my humble submission is that page 55, the relevant portion is last portion. If lordship permit me to read, your Honor. Mr. Lanes, Gogoi Lanes standing counsel and appealing for the writ petition submitted the submissions advanced by Mr. Hazarika regarding the provision of an appellate remedy being available against the impugn order is correct. Mr. Gogoi also fairly admits that the impugn order was passed in civil suit title suit number 06 of 2005. Mr. Gogoi therefore leaves 6 leaves of this court to withdraw this writ petition with a liberty to file an appeal against the impugn judgment order before this court. Thereafter, your lordship, the pair is not opposed by the learned counsel or the respondents. In view of the above, this petition disposed of and withdrawal with a liberty to prepare an appeal before this honorable court. The most relevant point in the next page, your lordship. Since the proviso of section 3 of the orders of 1954 permits the High Court to admit an appeal by condoning the delay in filing the same, it would be open to the writ petitioner to make an appropriate application seeking condonation of delay in filing this appeal. Considering the facts, the petitioner processing to file an appeal against the impugn judgment order, office to retain the LCR for a period of 6 months. Accordingly, your lordship, we had procured the certified copy and we had filed. And that 11 point of time, your lordship, since there is no district and session judge at half long, your lordship, so we had filed as an RFA. This is the matter, your lordship. Now, after judicial separation from the executive to the judicial, your lordship, an order, new amendment order has been passed, whereby my learned senior counsel want to point out this matter will go to the division bench. Otherwise, this matter which we have been filed as per the provisions of the law as directed by the single bench order. And accordingly, we have filed this case. And the pleadings have already been completed. In the meantime, we had all delay condon have been done and we had imposed 1 lakh rupees for delay of condon. And that also when we have complied to the honorable court's order by the NFL. Now, at the gist of the meats of this case, you in a single bench, now my learned senior counsel has pointed out that this matter may be go to the division bench. After imposing 1 lakh rupees penalty cost for being delayed. And we admit this that this is our part of the NFL.
What do you want to?
Without going through the merit, this is the gist of the case which I have found. Earlier, if
But the LCS, is this the LCR? I think this is the LCR of the miss case.
No, lordship, if page 56, considering the facts and circumstances.
No, that
LCR that time, my lord, gone.
That
because 6 months, it is the order passed to keep the record for 6 months. Then, my lord, it is stand back because 6 months already expired. Again, my lord, LCR has been called for. Now, LCR is available in our court, my.
It may be.
It has already been sent and it is put up on record, my.
last occasion I have gone for the
How
LCR.
many LCRs are you?
LCR put that one.
I'm just touching the office note also. This one.
Last.
If Lordship permit me one point, Your Lordship. 16/6/2023, this honorable court has directed to apply before this honorable court as a division bench to educate the matter.
It has been sent back.
Lordship.
Reports have been sent back.
After 6 months, it's been,
Oh, it
because
was-
title execution is proceed on perhaps, no?
25/2023. After that, let's see. I think this is the LCR. Twenty-five, 23 was sent back. Now 13/6/2023. We'll see records. That's been received. Is this the record? Okay, let us check out whether the LCRs are here or not.
Lordship. Only one point, Your Lordship, I want to highlight it. The judgment which have been passed by this on by that original court on 10/12/2013. At that 11 point of time, there is no judicial or any separate of from the executive to judiciary. In that 11 point of time, we had filed this case on the basis of this honorable court as an RFA. Now, the question, substantial question of law, whether it can be heard in a single bench or by before this honorable court. since the order which have been passed by this amendment act is prior to the order judgment passed by this court here, that judge.
Okay.
And second thing is that all the pleadings have been completed in a single bench. It is a stage, otherwise it is in the stage of hearing. Delay has been condemned.
We are concerned with the records.
Yes,
We're
sir.
not finding the records here.
Your Lordship.
Just say,
And also, Your Lordship, a copy may be supplied to where they have filed before the registry.
okay, one minute. Office note indicates, office note dated 13/6/2023 indicates that the LCR record of PS case number 6/2005 consisting of one file has been received from the office of the Deputy Commissioner Dima Hasso Haflong. Stop. Para. However, comma, we notice that only the case records of Miss case number 25/2014 is on record. Stop. However, we notice that the LCR of Miss case number 25/2015 is tagged with the records. Stop. Registry to verify and place the and list the matter again on 2nd February.
Maybe in 3rd February.
3rd is a Saturday.
Last week of February.
Huh?
Last week of February.
2nd is the first week of February.
Last week of February.
Huh.
Last week.
2nd of February.
Second.
2nd of February.
Lordship, copy may be supplied otherwise.
What
They have filed on registry.
So registry my lord, regarding my lord, sending this matter to division bench regarding it is an RFA my lord, which we filed before the single bench matter. And my lord, that the honorable single bench passed the order that it should be sent to division bench my lord on the basis of the submission made by them. That submission my lord has been my lord on my lord the registry they have filed an application before the registry my lord that it should go to the division bench. That application my lord, a copy of the application, why it my lord is sent to the division bench. We want to get a
Okay,
copy. my lord.
let us verify after the record comes.
Well,
We'll see it.
Obliged.
I'm deeply obliged.
Item 38.
May I please, your lordship? This promoter WPC is regarding lordship reforms of jail lordship. Lordship, as per the last order lordship, report of conducting inspection of prison is called for lordship from government of Assam lord.
Yes, not.
Well, on 21/8/2023, we have filed an affidavit. In that affidavit, the inspection report in respect of 29 jails have been submitted.
How many jails are there?
Total 31 jails. In Assam, 31 jails are there. And report in respect of 29 jails were submitted before you.
How about the other two?
But the other two are open air jail and Haflong sub jail. In respect of those,
when did you file your affidavit?
On 21/8/2023.
21/8/2023. You have the copy?
Well, the State Legal Service Authority, they have submitted the report, and that report we have annexed in the act.
That report is not here. Your affidavit, isn't it?
Yes, my lord.
Date?
21/8/23.
21/8. Just check up.
Look, I'll
What file you are giving me? It's part 2 file. Hmm? No, this is the part 2 file. This is the part 1 file.
in online it is shown as 22nd of August.
You're correct. It's here. Huh? You have a copy? Is that part 1 or part 2? What file is this? Oh, it is affidavit file.
এখানে নাই, এখানে নাই। আমি রিসেন্ট মেরে
Mr. Dilip Saikia, he has signed. Dilip Saikia is the deponent.
When are you filing the other affidavit?
Well, in fact, well, the matter has come up after a long time. I'll in the meantime get the instruction in respect of the other two. And well, I have also received one communication that they have said that steps have been taken for appointment of doctors because there are no permanent doctors in all the jails. Only in respect of 6 jails, well, there are permanent doctors. That instruction also I'll incorporate in the meeting. I'll get both the instructions. In the affidavit, has not got the affidavit. Page 506. Page 506 is the first report. This report is in respect of 12 jail. And
Yes.
and annexure 2, Malad, page 517. This is in respect of P Gates. 517. And next, Malad, 527. This is in respect of the remaining things, report.
14 jails.
40.
14 plus
14 plus 12 and 3. 506 is 12. Then 517, 3, 15, and 527, 14. Total 29.
Yes. But Mr.
M.K. Sharma law.
M.K. Sharma.
N.K. law.
N.K. Sharma Leonard Counsel for the
On behalf of Mr. H.K. Das, Lordship, Standing Counsel.
Council appearing on behalf of Mr. S.K. Das, Leonard Standing Counsel, Guwahati High Court. Stop. The respondents have filed an affidavit on
22nd of August,
22nd
23.
August 2023, wherein it is stated that wherein the inspection of 29 jails has been placed on record. Stop. Mr. D. Nath Leonard, Senior Governor Advocate, submits that he'll be filing an affidavit with regard to the other remaining 2 jails within
Lordship, give me week's time.
within a period of 2 weeks. He also indicates that that in most of the jails there are no doctors available. And
Permanent
according-
regular doctors are not there.
there are no-
As and
no
when required,
regular
they are being
doctors
provided.
available. And therefore, the respondents are taking steps, correct?
Yes.
To have regular doctors in all the jails in Assam. Stop. He also submits that he will be incorporating the same in the affidavit, which is to be filed later. Stop. Allowing the prayer made by Mr. D. Nath, then as Senior Governor Advocate. List the matter again on 2 weeks. 7th of February. Is it all right?
Let it be on 8. The other matter is on also 8. On 8.
8.
Completely obliged.
Item 39 to 42.
My lord, some arrears were to be paid, my lord. As per my latest instruction, my lord, on 18th, the money has been sanctioned. So in the salary of February, my lord, the payment would be reflected, my lord. In the salary of February, coming February, the payment would be reflected, my lord.
You paid the arrear salary?
No, my lord, the sanction has been received on 18th. So the next month, my lord, salary, it would be reflected, my lord. So if it is fixed in the first week of March, by then, my lord, I can file the complete compliance.
Should it come in the
Mr. P. Pathak Leonard, counsel appearing for the respondents. Is this a sanction order?
My lord, this is the communication to me, my lord, that these are the steps that have been taken.
On the basis of instructions. submits that the revised salary of 6 left out working cases will be dispersed in the month of January 2004, comma, the budget for area payment of salaries, area payment of wages for all the 98 cases has been received, and the area wages will be paid by 29th of February 2024, correct? Stop. He therefore submits that some time may be given to the respondents to make the area wages to the petitioners. Stop. Prayers allowed. When do you want?
First week of March.
List on 4th of March.
Obliged. Deeply obliged.
Item 45.
Yeah, please, your lordship. Lordship, this is an application for condonation of 111 days delay. Lordship, though the petition is very voluminous, lordship, 760 respondents. At this stage, lordship, may I pray a notice be issued, lordship, and
Can you take steps?
lordship, I pray that lordship, till 755, I may be allowed to do a paper publication substituted service. And
how many respondents?
760, lordship, at page 154, and 59, I'm sorry, lordship, 758 to 760 is the Mizoram University. That lordship I will pick. 757 UGC, and 756 lordship is the union itself. I made a pro forma. But 1 to 55 is lordship private respondent.
Okay. Heard Mr. Architect Dev Chaudhary and Deputy Solicitor General of India for the applicants. Stop. By this application, the applicants are praying for continuation of 111 days delay in filing the connected writ appeal. Stop. Issue notice. Para. Learned Deputy Solicitor General of India submits as the list of respondents are voluminous. The applicants may be permitted to take service of notice on the respondents 1 to 755 by Dusty. Oh, no, by paper publication. By paper publication. Praise Allah.
Two local newspapers circulated.
Para. The applicants are directed to cost service of notice on the respondents 1 to 755 by substitute service by publishing the notice in 2 local newspapers having wide circulation in the state of Mizoram.
This is from universities in Aizawl, lordship.
Aizawl, so it has to be in Mizoram.
Mizoram.
In the state of Mizoram. In the state of Mizoram. I said in 2 local newspapers. No? Within bracket, you say 1 in vernacular and 1 in English. Within a period of?
Lordship will give me 3 weeks time.
Within a period of 3 weeks. Showing the returnable date as 1st of March 2024. Stop. Draft. The applicant shall file an affidavit to that effect. Stop. Para. The applicants are also permitted to cost service of notice on the respondents 757
Seven five seven to 760.
To 760 by registered post AD within 1 week from today. List the matter on 1st March 2024.
So
Item 52 from supplementary list.
Lordship, we are for appellant service is completed for it may be listed for hearing within an early date.
My lord, I have a brief prayer, my lord. In this case, while the writ was filed in a single report to the judge, there was a stay order. And on my application for vacating stay in an IA, that was vacated. And thereafter, in final hearing also, writ was dismissed. But in spite of these orders, my lord, the department is not giving me the benefit of provincialization because provincialization was stayed of respondents 7, 8, and 9 of the school. And they take the plea that since the appeal is pending, you will not give you the benefit. So I pray for a special order from your lordship, my lord, so that the benefits of provincialization may be furnished to the respondents 7, 8, and 9.
My lord, I have serious objection because.
Why? There is no stay order.
No stay order, but they obtained the order concealing material facts. There was a order was struck down, but that was not mentioned in the interim order, which was granted by the learned single judge, though it was before him. So on this point, we have because he has no document. The other party they have no document, and we have 33 documents. Why is it coming for orders today?
Services
Short date may be fixed for final hearing, my lord. I am ready. When is it? Service is completed, so matter may be listed for hearing any day as my learned friend desires. I have no objection. Respondents 6 to 9. You are appealing for
7, 8, and 9.
7, 8, and 9. So notice is complete. Yes, service is complete. Who is 6? Who's 6?
6 is a government department officer. Cluster resource coordinator is a government officer. I think that is covered by the state service.
It is CSCC, my lord. He is the trouble creator of all this. He has secretly sent a report. He is very junior officer. Joint Secretary reported in our favor after thorough verification, but he secretly has communicated all this without our knowledge.
Joint Secretary order.
This is only this person is responsible for all this. Government order is in our favor. DO is in our favor. Learned counsel for the appellants. Stop. Mr. H. Aliel,
appearing for
senior counsel assisted by MS M. Enters appearance on behalf of the respondents 7, 8, and 9. Stop. Who appears for elementary education? Mr. R. Majumdar, learned standing counsel school education department appears for the respondents 1, 2, even 6. No. But it's 6 4 and 5. P. Nayak. And Mr. P. Nayak, learned standing counsel associate for the respondent. Stop. List the matter again on when? List this matter on? For hearing any day or lots of next week. Admission. Okay.
In February,
2nd February.
Monday.
An attempt may kindly be made to dispose of the matter on that day.
That we'll
Because
see.
since 1994, we are not getting salary. Man. Okay, please.
Yeah.
You have your served copy?
Yeah.
Yeah. You file an extra copy. It's completed. However, I will. But official says that everything is completed. Okay, I will give. No problem. I will give.
Item 50 and
All right.
51 for hearing.
Here, are writ appeals. I'm told that similar appeals have been filed recently and are up for admission. Maybe if they are taken
In the morning, I mentioned that April 3rd, there which will come on Wednesday, Lordship is allowed to mention. Therefore, this matter,
These are batch matters, my lord, which
So,
are only
any
disposed of by one order. So order in one of them may affect the others also. Perhaps
if any date, the matters of Wednesday can be fixed with this matter when it comes. No, witness day, we are fixing one matter, isn't it? Yes.
That is for,
That is yet to come. Yes.
that is
So-
yet to be admitted.
So what do you want in this 1551 today? You want it listed on witness day? No.
Cannot be, my lord, because those will come up for admission. This is for hearing.
Hmm.
If lordship has these matters at our request sometime in the first week of February, perhaps, my lord, those matters can be admitted and we can take up all the matters together.
Yes.
That is what I would suggest.
Yes.
If convenient to the court, my lord.
50 and 51 on request made by the parties. When do you want February?
Any date, my lord, February, any.
Because in that the new notice has to go.
Yes.
No, notice has not yet been, it will come as a press matter. No, that's why, are there any private respondents? No private respondents. All official.
No,
All
no,
official.
all of it. We can take it.
15th?
Deep. I'm obliged.